Good evening, everyone. I'd like to call to order the Whatcom County Council meeting for March 7th, 2017. Could you please call the roll?
Barbara Brenner.
Here.
Red Brown.
Here.
Barry Buchanan.
Here.
Todd Donovan.
Here.
Ken Mann.
Here.
Satpal Sidhu.
Paul will be arriving in about 10 minutes. He had something he had to attend to at City Hall.
Carl Weimer.
Here. Okay, please rise and join me in the flag salute. I pledge allegiance to the flag
Of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, a couple of quick items. If you have your cell phone with you, please place it on vibrate or off. And if you'll be handing out any paperwork during either any of the public hearings or the open session, please provide a copy over to staff. We had one item today from the Committee of the Whole, a discussion with Chief Civil Deputy Prosecutor Daniel Gibson regarding pending litigation on Swift Creek. There was no action taken. Our first item tonight is a special presentation, and we'll start out with a video presentation to provide information related to the Supreme Court's Hearst decision, followed by a time for us council members to address our panel of experts in answering some questions. So with that, I will turn it over to our legislative analyst, Forrest Longman, to introduce the video and then show it. We will adjourn to those chairs then.
Oh, okay.
So we can see.
Yes, so the video is selected excerpts from a State House Representatives Committee hearing which occurred on December 1st, 2016, discussing the Hearst decision. It includes testimony from ecology, water right experts, USGS, and State Association of Counties.
So just a very brief water law background that we adopt in-stream flow rules under the authorities in two statutes. 9054 is also referred to as the Water Resources Act of 1971. Now, before the 1990s, so in the early days of our in-stream flow making, our in-stream flow rules regulated permitting of surface water and groundwater, and the language in the rules focused on significant or direct hydraulic continuity between groundwater and surface water. In 2000, the Supreme Court decision under Postema, they ruled that even de minimis impairment, so that would be even very small impairment that can't be measured except, for instance, through mathematical models, that could not be permitted. So there is, so they changed the standard from significant or direct hydraulic continuity to any impact. And the reality is that there's some degree of connection between almost all surface and groundwater, and you've got a panel of hydrogeologists going to explain that in greater detail. Now, the GMA background, there's three main statutes that the GMA relates to the Hearst case. Number one, the general GMA requirement that rural development must protect surface and groundwater resources. Another one is the building permit statute, RCW 19-27097, which says that counties must make an adequate water determination for the intended use of the building, and that's a part of the building permit approval. And then also there's a requirement in the subdivision statute in RCW 5817. So in the Hearst decision, the Supreme Court didn't reach to the Nooksack in-stream flow rule that was adopted in 1985. It didn't speak to the rule other than agreeing with ecology that the rule did not regulate permit exempt wells, that it only applied to permitting authorities from ecology. But they did say that the GMA requires counties to go beyond the in-stream flow rule. And so in their permitting authorities to look at the impacts to those in-stream flows and ensure that there's no impairment associated with any land use decisions. And thus they ruled that Whatcom County cannot issue building permits or subdivisions that would impair in-stream flows, even though the rule didn't restrict those permit exempt uses. So the implications for the rest of the state are pretty significant. In this map, I show the rules that were adopted in orange before 1990, and then there was a hiatus in rulemaking, and then there were rules adopted after the Postma decision. So the rules in yellow are the post-2001 rules. Now, all of the rules in orange do not have any allocations or reservations of water for future development. So people have to rely, or they have relied on the permit exemption for their source of water in rural areas, and that's the direct issue at issue with the Hearst decision. So you can see that with all the orange basins that all of Puget Sound is affected by the Hearst decision directly. Those basins in yellow have reservations of water, so there is water available for people for new uses for domestic. And then just one side note about the Metah Basin, it was amended to add a reservation.
My presentation is going to just go over some basic water law information that this is kind of the state of the law in the state of Washington. So what is water law? It's made up of court decisions, statutes, and agency rules, and it's important to know that the agency rules are the third wheel. They're not the drive shaft, it's the third wheel. So it is the court decisions and statutes that control. A water right is a water right. There are no good water rights or bad water rights. There are no partial water rights or full water rights. There are just water rights. And in our state, the state-based ones, these are the basic ones. You've got agricultural, industrial, domestic, municipal, there's some power generation, and in-stream. The cornerstone of water law, the cornerstone, is the priority system. First in time is first in right. An old senior water right gets all of their water before a new junior water right gets any. If a junior water right impacts a senior water right, the new junior water right is shut down or curtailed. The agency does not have discretion on this. This is court and statute that has directed this, so the agency does not get to have discretion on deciding that. In-stream flow water rights, where'd they come from? Well, the statutes, legislature passed statutes that says we need to protect and preserve in-stream resources. The Supreme Court has ruled that in-stream flow rules create in-stream water rights. The priority dates of those water rights are the date of the rule adoption. So if you have an in-stream flow rule, it has an in-stream water right. Its priority date is the date that the rule was adopted. So what does this mean? It means, like all other water rights, an in-stream water right cannot impact an older senior water right. An in-stream water right can shut down and curtail water use by new junior water rights, because first in time is first in right. Are exempt wells a water right? Yes, they are. There's a long and convoluted history around exempt wells. Exempt wells simply means that you do not need a permit from ecology to start withdrawing. But exempt wells are subject to all the other water laws, rules, and regulations, including first in time is first in right. So what does that mean? Like all other water rights, an exempt well cannot impact older senior water rights and can shut down or curtail water rights that are new or junior water rights. Hydraulic continuity, what? Yes. Surface water is river water, groundwater is underground water, aquifer water. River water seeps into the ground, and groundwater seeps into the river. For those of you familiar with it, you've heard of gaining and losing reaches, right? So there is a connection between ground and surface water. On the whole, this does not happen in equal proportion. Usually it's the groundwater that is, mostly it's the groundwater that seeps into the river. So generally, when a new junior water right taps into the groundwater, and it takes water that often would have ended up in the river, would have been in the river before that junior started tapping it out of the ground. This can be a problem, and it's especially a problem in a closed basin. So what's a closed basin and why does it matter? When all the water in a basin or a sub-basin has been allocated to existing water rights, the basin or sub-basin is close to new water rights. If a new water right is allowed in a closed basin or subbasin, it is taking water that is already allocated to senior water rights. This is a violation of the basic foundation of water law. First in time is first in right. So where are we today? We're under new management. Under the old system, ecology regulated water rights and determined whether water was available. They would close a basin when the water had all been allocated. Off to the side, counties have building permits, and their building permits require that there's water available for them to approve the building permits. Unfortunately, ecology doesn't always tell the county that water is not available. So the county approves the building permit and new water rights with new water rights in a closed basin, and ecology struggles with this first in time, first in right law. And so what did the court say? It said the state does not have to tell counties whether water is available, but now counties have to figure it out and legally responsible for those decisions.
A brief conversation about an overview of hydraulic continuity. It's basically the interconnection between groundwater or aquifers and surface water sources such as rivers, streams, and lakes. An aquifer is in hydraulic continuity with wetlands, lakes, streams, rivers, or other surface water bodies whenever it is discharging to those water bodies. Dave Masson mentioned that earlier. And that continuity also exists when the aquifer is being recharged by surface water. So hydraulically connected groundwater and surface water cannot be considered independent resources. A withdrawal from one will have the same effect on the other. Here's a simple side view cross-section put together by the Geological Survey several years ago. We have a recharge area. Looking at side view, groundwater in an unconfined aquifer migrating from a higher head location, higher elevation, gradually downstream, down gradient to a nearby stream. You put in a well and pump that well, and that well withdraws water from a 360-degree cone of depression or circle as it's pumping. And over time, it can impact the flow to the stream by reversing the gradient to take water from the stream. That's an example, a simplistic example, but multiply that by several hundred, or in some basins, several thousand exempt wells and large production wells with water rights in a system, and pretty much you've reached a point of basin capacity. On top of that, you have a variety of aquifers, especially in the Puget Sound lowland. There's generally 3, if not more, aquifers, an upper unconfined aquifer and middle and deeper aquifers that are confined. The flow paths from recharge areas to those aquifers and then eventually to wells and or streams can take anywhere from months to several years to centuries and millennium. So groundwater flow paths vary greatly in length, depth, and travel time from the point of recharge to points of discharge in the groundwater system. On top of that, you have, especially here in Washington, our big challenge as hydrogeologists is that we have a wide variety of subsurface geological conditions. We have river and stream alluvial deposits, glacially deposited sands and gravels intermixed with glacially deposited silts and clays. Those are generally the confining layers. We have a variety of fractured bedrock throughout the state, mainly fractured basalts in eastern Washington and parts of western Washington. And we also have a variety of sandstones and granitic rocks, siltstones, and other types of bedrock. Our state's geology is very complex. It's not the Ogallala Aquifer of Nebraska. So the challenge we have as an agency, as regulators, as developers, as environmental protection interests, as tribes, is under this posthumous Supreme Court decision, an impact to a closed stream or one that isn't meeting flows regularly is impairment. It's virtually impossible for a well within any given watershed to not have any impact on surface water, lake, stream, or river, the exception being marine water discharges. A well, for example, very close to salt water here at Puget Sound may not impair the stream. However, if the well is overpumped, you could have seawater intrusion, and that's a whole other issue. Groundwater and surface water are connected in some, however small and indirect way. It's virtually impossible to manage on-off schemes for wells to address periodic in-stream flow exceedances. such as different flow paths, the timing of impacts to streams between winter and summer, and a variety of other enforcement issues. And it will be difficult to do a hydrogeological evaluation that will not show at least a de minimis impairment to a stream. While in some cases, based on location and well depth, this could be possible, it will be a costly evaluation to conduct.
USGS is a federal science agency. I work for the federal government. We are a non-regulatory agency. We have no enforcement authority. We don't do management. We don't do enforcement. All we do is provide impartial and unbiased scientists to groups like this one that are trying to make good decisions about how to manage their resources. So with that in mind, I'm going to not talk about the legal specifics of the Hearst decision, but I will try and provide some background on what the work we have done in partnership with local governments and tribes and water purveyors might be able to say about possible solutions to this problem. Okay, so in general overview, water use from permanent exempt wells is a tiny portion of the state's water budget. It's about 2% of water withdrawn, and about half of that is used consumptively on an annual basis. So keep in mind that we're talking about a amount of water that is within the range of a solvable problem here. But that small amount is not zero. Water withdrawn from groundwater systems does impact surface water and therefore senior water rights. By conservation of mass, if you pull water out of the ground, there will be an impact somewhere. So those impacts can be difficult to determine. They are spread out in space and in time. They might be years down the road. They might be in different locations, but there's always going to be an impact. That impact is commonly too small to measure for an individual domestic well, but it is not too small to measure cumulatively if you look at all the domestic wells in a basin. And then I'm going to talk a little bit about some of the groundwater models, like the Yakima, that we have built over the past few years that have analyzed this problem and have made predictions about how much stream flow has been reduced as a result of exempt wells and where additional water might be found. So this pie chart has in pinks and reds all of the groundwater use in the state. It's about 1/3 of water use is groundwater. Of that 1/3, about 7% is domestic wells. So statewide, it's only about 2%. So the big slice there, the big dark blue one, is of course surface water irrigation. Most of the water we use in the state comes mostly out of the Columbia and is used to grow crops. So keep in mind that 2%, half of which is acceptably used, is a small amount of water to find in this pie chart. He already showed this figure, or an ecology version of our figure, but I won't go over in detail. The key point here is that that well in the second and third diagram changes the flow direction of water in the aquifer, and those changed flow directions either pull water out of the stream, thereby reducing stream flow, or intercept water that would have ended up in the stream, thereby reducing stream flow. Right? So unless we have more water arriving through precipitation, when you pump water out of the ground, you reduce discharge from the aquifer somewhere. If it's a very deep well, it could be an impact 30 years down the road, but it will be an impact.
Counties have separately elected prosecuting attorneys that give legal advice to the county. And when this court case came down, they looked at kind of their local occurrences with water, local laws they've dealt with, cases they've dealt with, the risk level they were able to take. And many of them have not taken any action, but several of them have, and it's kind of all across the board. You've heard from Whatcom County with their moratorium. Spokane County right away, so enacted by the end of the month, around the 26th of October, that you were required to do a hydrogeologic study if you were within the in-stream flow area, if you were in an area that wasn't necessarily in the in-stream flow, if you had if you built 500 feet away from other water bodies that you might impair, then you could move forward on a building permit. As you speak to them, a lot of their rural lots are 10 acres or larger, and so there's some of those ability to do that. But there's a lot of places that don't have 10-acre lots that a 500-foot setback would again also be kind of an impossibility. Pierce County, effective November 1st, instituted that if you are wanting a permit exempt well, you have to have a licensed hydrogeologist stamp a report that shows you are not hydrogeologically connected to water. Therefore, you would impair that. Okanagan County is a non-GMA county. That's another piece that is not very clear. This says it's a GMA case. You have 10 counties that are non-GMA. Some of them have in-stream flow levels. You have GMA counties that don't have in-stream flow levels. It's unclear how is this then impact pretty much the whole state. In Okanagan County, I said, but they are having permits go through a hearings examiner so that they can build the record as to what the situation is around water, site by site, site specific for an applicant. Stevens County is, as reading it under a GMA case, will address it as they do their comp plan update. So the 29 counties that are in GMA, there's several of them who are just at just about over the finish line of their current update. Then you have the next slate of counties that will be doing that in 2017, and then the last slate of counties that are doing their updates for 2018. And they're all trying to determine how are we going to address this in our comp plans updates. For those that are almost finished, that have been working on this for a couple years and lots of dollars later, they're concerned of how they're going to be appealed on their current update. You have kind of the discussion then on the cost and the benefit of this. If we are all looking for improvement in stream flows, if we are looking for improvement in fish habitat, water resources, how do we protect them? In a lot of the other things that we all deal with, we balance cost and benefit. So let's say you have someone, an individual, and I've heard different prices out there. Let's just pick $10,000 to do a hydrogeologic study. And they prove that they are connected to the stream. Then what do? Are they in a place where they've got mitigation options and then they need to spend another $10,000 on a water bank piece? Let's say those water bank pieces aren't available. There's lots of counties that don't have that option. And there's other case law that even makes that worse. Foster is a case you'll hear about that has changed the abilities that you have to mitigate. So you now can't, there will be places available where they won't be able to do water banks because the water rights available now can't be transferred for a different use. So then they're stuck. They can't build on their land. Let's say someone spends $10,000 on a study and they're not connected and they get to move forward. So the cost to that individual citizen didn't create a lot of benefit for the stream. So where do we balance that cost benefit? Where do we look at some of these other costs? So in Pierce County, there are citizens who want to move forward who can't. So they have put $40,000 to $60,000 in all the different types of permits that you have to grade and to do a road and to do a septic and to get your well, and now they're dead in the water. Will the county be liable for damages? That's very possible. What's the cost of the stop of rural development in our state? There's lots of revenues that come to local and state government from development that is now going to be pretty much on a moratorium until we can come forward with solutions.
Okay, we'll move into our panel and questions from the council. If I could get you all to introduce yourself and give us just a little brief bio, very brief.
Mr. Chair, if I may, just before,
Yes.
if I just make a comment. The video you saw was about 20 minutes of a 2-hour presentation. If you'd like to see the whole thing, I think we can put up the link to the whole video, but it's 2 hours of different pieces of information on that particular topic. So.
Okay, go ahead, Tadas.
Good evening. Tadas Casilius with Van Ness Feldman. I am outside counsel. Just worked with the county on the Hearst case. Worked with Deputy Prosecuting Attorney Karen Frakes, both at the Growth Board all the way up to the Supreme Court.
My name is Bob Carmichael. I'm not sure exactly why I'm here, but I'm a local attorney, formerly with the prosecutor's office in Whatcom County, about 8 years, and then about 24 years after that in private practice with the firm Carmichael Clark at this point. I practice in land use, water law, and municipal law.
That's why you're here.
My name is Chuck Lindsay. I'm Senior Principal Hydrogeologist with Associated Sciences, and I act as the third-party technical review for the county for Hearst-related reports. Is that better?
Yes, thank you.
Want me to repeat that?
Sure.
My name is Chuck Lindsay. I'm Senior Principal Hydrogeologist with Associated Earth Sciences, and I'm currently acting as the third-party technical reviewer for the county for Hearst-related reports.
I'm Steve Jilk. I'm the General Manager at the Public Utility District here in the county. I looked at the announcement, and my wife suggested that she didn't know I was an expert in water. And I said, my dad used to always say an expert is just a drip under pressure. So I think the reason I'm here is that I've had about 23 years, 23 and a half years working in Whatcom County, first representing some of the small cities in the county, and then working at the port, and now working at the PUD for the last 11 years. And most of those years, those 23 years, been working with the county and other cities and Department of Ecology, Department of Health on water-related issues. So.
Okay, thank you all. I guess to start out with this, does anybody want to do any opening comments on the video, or do you want to just dive into questions? I take that as a dive into questions. Okay. Ms. Brenner?
Can I do an opening statement on that video?
No.
Oh.
Yes, you can. Of course you can.
I thought the video, and I saw it before too, and I'm very disappointed because I thought it was not a balanced video. It was mostly one side only, and that was disappointing to me. And I think it would have been helpful if all of us had some input before something like this happened. Anyway, I would like to ask, since I was on the council when Bob Carmichael worked as the council's attorney, so I would like to ask him if he believes that the way, I guess I shouldn't make it too broad. What do you believe might, and this still might be broad, what do you believe might be lacking in the information that we have and related to what we could possibly do to allow people to develop their properties?
That is too broad, but
Well, do whatever you want with it.
So one thing I will say that I really haven't seen any discussion about, and this surprises me, is the basis for the in-stream flow rule in the first place. The court made some statements in its opinion, the Hearst court, that indicated it was relying on the fact that the county failed to meet in-stream flows for 100 days out of the year in the Nooksack Basin. And it used that as evidence or argument, if you will, to support its position that the county had failed to protect water resources. And what surprises me about that is if you go back and look at the underpinnings of the Nooksack rule, there's a 200-page document that is entitled Nooksack In-Stream Protection Resources Program. And it's very clear from looking at that document, and I've confirmed this afterwards with discussions at people at Department of Ecology, that the Nooksack rule, in-stream flow rule, is based on a 50% exceedance standard. And so in reality, what it is a median of historic flows, average historic flows, over a certain period of time. So during that period of time, there are hydrographs, by the way, in this document. And they show that what the flows are over long periods of time for most sections, some of them longer than others, for most sections of most basins. And there'll be a line where the in-stream flow is set, and the objective was to try to set that at 50% so that the flows were more than that 50% of the time and less than that 50% of the time. Now, they did do some modeling. There was an IFIM model. That's the acronym. I won't get into it. There was that they used from U.S. Fish and Wildlife Service, and there was another model from another agency. But the overriding principle was to, at that time, let's set the in-stream flow at the median historical flow. And so what that means is the flow was going to be breached. It was going to be below the minimum in-stream flow 50% of the time. So to say that the in-stream flow wasn't met 100 days out of the year really doesn't mean very much to me if you're looking at it. I'm just trying to look at it objectively. Why is that evidence of inadequate protection of water resources when that in-stream flow rule is simply a median average historical flow? The other thing that troubles me a little bit about the decision is it picked the breach and said, hey, look, you're not meeting these minimum in-stream flows, but then the court ignored the fact that the rule itself accommodated exempt well withdrawals. And those exempt well withdrawals were part of the rule. So it relied on one part that said, hey, you're not meeting this in-stream flow, even though really it has no consequence in reality that it's not met. And we're going to say, look, you breached this, so you're not protecting water resources. But on the other hand, we're not going to recognize the part of the rule that allowed for exempt wells. I think when ecology set out that rule, if you go back, I don't mean to monopolize all the time, so if you want to cut me off, go ahead. But back in 1985, as many of you know, and I've heard by now, really hydraulic interplay between surface and groundwater was not well understood. Maybe certain hydrologists understood it, but I don't think a lot of policymakers understood it. And so it was not considered to be a problem to simply, let's set this flow at 50% at the median. We know that there will be exempt wells available for groundwater withdrawals. Part of the understanding that went around all of this is that when ecology sets minimum in-stream flows, they're supposed to, at least under the Water Resources Protection Act, which was one of the statutes you saw on the screen that is responsible for the in-stream flow portion, 9054, requires that there be a maximum net benefit analysis done at the time those minimum in-stream flows are set. So the problem is that ecology didn't do that when they set the minimum in-stream flows in 1985. They didn't do a maximum net benefit analysis. And that maximum net benefit analysis under the statute was supposed to consider out-of-stream uses of all sorts, domestic, industry, agriculture, balance it, come up with a minimum in-stream flow and provide for out-of-stream uses. What I think part of what ecology did, and all of these are just my opinions, but I think part of what ecology did in 1985 was they took that out-of-stream portion and relied on exempt wells to satisfy it. And again, called it good at 50% for the rule. Really what we have now with the evolution of the science of hydrology and better understanding of hydrological principles and continuity, and the development of case law at the Supreme Court, which may or may not have totally understood that over the years, we have a situation which is untenable, really. I think it's kind of out of balance right now, unfortunately, where the reserve that was supposed to exist, because we've got this language of minimum in-stream flow, we know really the basis for it is not there. We have a problem, and people can't they can't get water for exempt wells. So this has been a problem a long time in the making. The solutions are not very obvious. If I had one, I would that was clear and easy, I would give it to you. You've been pondering this for a long time. Obviously, this is a problem that could be fixed legislatively. I know there's a couple bills in Olympia. The legislature could fix this. Certainly citizens and council members can request legislative fixes. Ecology could fix this with a new in-stream flow rule. I wrote a letter on behalf of a client probably 2.5 years ago. It was a long letter. I don't know how many of you remember it. Some of you weren't on the council. It was actually in response to a request of Mr. Weimer for water action plans. And that letter, I basically set out a lot of what I'm talking about here, and actually said in that letter that the county needs to wake up to this problem. And it is a problem now, but I think ecology bears some responsibility for it because they really haven't done anything. We've known since 2000 under the Postema test that we had this problem with hydraulic continuity and in-stream flows, and we've known that if you have an impairment or if you have an impairment of in-stream flow from groundwater, that you are not going to be able to secure a water right under that Postema standard. And we've known that this rule, the Nooksack rule, is not a very sound rule. And there could have been something done, and there probably should be something done about that. So there's rulemaking, there's legislation, there are the things that you could do at the local level would be to try to come up with creative mitigation programs, working with people like Mr. Lindsay. You could really put your shoulder to the wheel, create a task force to try to get at some of these problems. They're not easy to fix, but I do believe that there are things that could be done even at the local level. I don't know that I've answered your question, Barbara, but I went on long enough.
You did
so
fine.
I'm going to yield the floor at this point.
Mr. Donovan.
Yeah, I actually want to follow up on Councilmember Brenner's questions and some of those points. And I'm interested to know more about, could ecology just change if they came up with a new in-stream flow rule? Does that deal with Postema and Foster and Hearst? I'm not so sure about that, but I guess for everybody, ideas about, there's multiple things we're trying to do here is figure out what we can do for people who are substantially forward in projects, and also then just the bigger picture of, let's assume this decision is here whether we like it or not, and there's the physics that we, of hydrological conduct, what do you call it? Connections. That even with the court stuff, that's not going away. There's not going to be more water necessarily coming in summer months. So what kind of mitigation plans could we do just conceptually? Maybe that's a hydrology question. And then what, for a lawyer, what could we do in terms of those sorts of mitigation things that could maybe open some stuff up now?
If you don't mind, I'm going to, Chuck,
yeah,
Lindsay and I, we're talking about that just before the meeting, and I'd like to turn it over to him on the mitigation part anyway.
Well, most single-family homes, when you have just a single-family permit exempt well, if you will, or what you refer to maybe now as a Hearst-type well, typically their indoor water use is in the range of, say, 300 to 500 gallons a day under typical use. And if you assume, let's assume it's 500 gallons a day, and you assume that 20% of that water use is consumptive, which is probably being a little conservative, it's probably a little less than that. But that means you've got somewhere around 100 gallons per day of potential impact that you have to mitigate for your well. It's really not that much water. There is a possibility of, Ecology has a rainwater catchment program now where you can actually you can capture the rainwater on your own property and use it directly as drinking water. It requires some storage and issues like that. That would totally remove you from any of this permitting issues. You're now dealing directly with the county health department as far as permitting it as a water source. Or the other option on that would be to maybe store less water from this rainwater and use it as mitigation water. Because again, you are required to mitigate your impact, which is 100 gallons a day. If you're using it for drinking water, you need to store basically enough water for roughly, say, 400 or 500 gallons a day. Probably the big problem would be through the summertime, is being able to have that much storage. But if you kept the water for mitigation purposes only, now you're talking about 100 gallons or less per day, so you have less storage, less cost. You would infiltrate that water into the ground, maybe beneath your driveway or something like that, so that it basically meets the Foster decisions or criteria of in kind, in place, in time. Another option for mitigation would be if there's a possibility that a nearby water association or water district or water purveyor has the ability to provide you some water via a pipeline. Maybe they don't have enough water with their water rights to give you your drinking water supply, but maybe they have enough water rights to give you some water for mitigation. And so again, same procedure there. You would have to develop a mitigation plan for both of those options if you're using the rainwater for mitigation or this other water, and then submit it to the county, and so the county could look at it and make approval of it.
The second part of it was, can we legally do that?
So, excuse me, with respect to that second part of the question, the interim regulations actually anticipate exactly what was just described. So there's an opportunity there through the interim regulations to submit mitigation to address the impact of your withdrawal. That could then provide a path forward.
My question is to Chuck, with your expertise. The way I look at connectivity, if it is really true that every groundwater and the surface water are connected, they should be connected everywhere. We have 1.2 million acres in our county. If we are looking at that when you draw the water, it lowers the in-stream flow. Now, tell us more about the recharge, because, the only way to recharge is that you have to have a large surface area to recharge if the aquifers are connected or the groundwater is connected, and we have a large surface area, which is uninhabited. How does that work? Does it has any meaning to this, that large surface area for recharge?
Well, it does, and not only that, but we're in Western Washington. We get a lot of rainfall here. Yes. So not only do we have a large surface area, but we have a substantial amount of rainfall. And of that rainfall, a certain percentage of it is it's removed from the aquifer or the system as surface water runoff that goes right into the stream fairly quickly. Some of it's used by plants, evapotranspiration, and the remainder of it generally infiltrates into the ground, and it recharges that first aquifer. For example, the Linden area, it's the Sumas Abbotsford aquifer, very extensive, fairly shallow, highly productive aquifer that a lot of people in the county use. But there are other aquifers below those too, that the water from the Sumas aquifer would percolate down through various sediment layers and get down and recharge some of those aquifers. So you are correct, there is a tremendous amount of water going through our system here from a hydrogeologic point of view. And we're talking about the impact of 50 to 100 gallons per day. It's pretty small. However, our standard that we're held to is 1 molecule. Yeah. So 1 molecule of impact to surface water is impairment. Yes. Under the regulations that we're using now. That's a very, very, very difficult standard to have to meet. And there are places in the county where we can show that you don't have, you can be completed your well in a certain aquifer that doesn't have any connection to, or at least any hydraulic impact on, some regulated surface water bodies.
I was going to say that 1 molecule rule should apply both ways. If it is only applied when you withdraw it that you have impaired, but how many molecules have entered 30 miles away or 30 feet away or 30 whatever, right? So, this is half the statement that impairment is only you're applying to withdrawal.
I tend to agree with you. You are correct. You could argue that there's a finite amount of water that falls on the ground surface in any one year, and you pump your well and you use some of that water, which draws some surface water down into the aquifer, then some of the water, the surface water during that time period that would have ran off and gone into the system and exited right away, would have then basically infiltrated in and filled in that void space. But that's unfortunately doesn't help us with our one molecule. You're still intercepting one molecule, and we have a system up here that for the vast majority of these small systems, they're closed year round, not just intermittently.
We'll go with Mr. Brown next.
Sorry, Mr. Casillas, did you want to make a comment to that? You had your...
I don't mean to drop it, I just wanted to make one quick clarification.
Yeah.
Oh, yes.
Which, just to, I think Mr. Lindsay had said that's the regulations we're using right now. The one molecule is actually not a county regulation. That's Supreme Court case law that we're talking about. They're not,
Yes,
not
yes.
anything we've
No.
imposed on ourselves.
Yeah. I mean, Supreme Court can be wrong also, so.
So we heard a bit of comment about the wisdom of previous Supreme Court decisions, and I won't ask you to adjudicate that here, but can you just comment, perhaps particularly directed to the two lawyers, do you think the county was wise to comply with the Supreme Court decision, because our other alternative was to ignore it?
The county, the county has to comply with the Supreme. I need some water. It's not got nothing to do with your question. The county has to comply with Supreme Court decisions. Question is whether you had to put the moratorium on when you did, and that's a separate question. There's no question you have to comply with the Supreme Court. With the GMHB decision that was on appeal to the Supreme Court, the context of the litigation was GMHB. And as a GMHB decision before the court, one of the questions was whether the court was going to retain the finding of noncompliance, or as Mr. Hurst et al. Requested before the court, find invalidity. The court rejected the argument for invalidity. And that was significant because invalidity means that any regulation to the contrary of the court's decision would have to be not enforced, not followed immediately. The court instead remanded it back to the board for further compliance proceedings, upholding the board's decision that the county ordinances were not in compliance. Thank you very much. Very kind of you. So, in my opinion, the county did not have to put the moratorium on when it did. I do understand that there's differences of opinion on that. I know different counties have treated this problem differently. Some counties have continued to process building permits, basically saying, good luck. If you get one, we're not standing behind it. That's not a great commercial situation to be in, by the way, but I understand that that's what King County and Snohomish County are doing. So they are continuing to process building permits. Other counties are not. It depends. It really is a mixture on that. I understand that there is a question of legal availability, and the idea would be, well, if you can't show legal availability in compliance with the court decision, then you shouldn't get a building permit. But I still think that in the rubric of the case, being in the context of a GMA case, GMA has very specific rules for what counties can and can't do when their ordinances have been overturned. And there's two levels. Again, one is noncompliance, one is invalidity. Invalidity is worse. Everything has to stop in its tracks. Noncompliance means you have some time. You can keep going with what you have in place, but you have some time to fix it. But by the time you get to the compliance hearing, you have to have fixed it. So I do think that you have to come up, you had to come into compliance. You have to come into compliance with the Supreme Court ruling. The question is when, and did you have to put the moratorium on when you did? I think that's, that's highly debatable from a legal standpoint.
I'd actually, if I may, I'd like both counsel to answer this question.
Thank you. I think with what Bob was describing in terms of the difference between Whatcom County and other counties, I think is worth emphasizing here. So you heard in the video Laura Berg describing some of the different counties' responses to all of this, and there's two schools of thought and different approaches to all of that, and that is something that Whatcom County does not have the liberty to sort of engage in that, because we are the named party in that case. So that is directly applicable to us in a way that other counties can have that philosophical debate and kind of make their own calculation on that. So that's, I think, an important point to make, that we are the county that is the named party in that case, that has proceedings pending before the Growth Board and an obligation to fix things. That's the first point that's just very important to emphasize. We can't compare ourselves and our position to that of King County, Pierce County, Spokane County, or whatever you want to sort of make as the point of reference because of that unique position. More generally on the moratorium, the issue here, I think, is what Bob, I think, correctly described as the garden variety GMA case. The nuance here that changes that assessment is the fact that the court's decision was not based solely on what's the county's obligation when adopting a comprehensive plan policy. The court's decision is replete with references as to what the county needs to do when processing building permit applications and subdivision applications, pursuant to 1927-097 and pursuant to 5817-110. So it's got different implications from a legal standpoint that the county needed to consider in deciding how to proceed in the interim, and I think that informs some of the decision making that kind of thrown into the hopper as to what's part of the process there.
If I may just follow up, one of the reasons I supported the moratorium was the fact that there was the concern about going into a declaration of invalidity, that going into the moratorium gave us the time to work to get into compliance and find solutions and work with the state legislature. So, that was I still, based on what I've just heard, I still believe that was the right approach. So.
Mr. Weimer?
Yeah, I guess hopefully a quick question for whoever wants to answer, one of the attorneys perhaps, is I was interested in the video. They made it real clear that just because you get a building permit doesn't mean you have legal water. And there seems to be this push and shove on both sides. We have people that are already impacted because they say their wells are being impaired already, and then we have a whole lot of people that want to develop. So I was just wondering if you can talk a little bit about, you said King County and Snohomish County are just continuing to give out building permits but telling people good luck with whether that's legal or what will happen in the future. What do people think county's responsibility is when it comes to dealing with that? Should we just be telling people good luck and letting them fight it out in the courts and stand back and have no responsibility, or should we be part of that responsible discussion?
Well, I think the court spoke to that in its decision. I mean, the court pretty clearly identified the county's responsibility when processing building permits and subdivision applications. It's there, it's in the text, and it's the plain interpretation. We did have, the arguments leading up to that decision. We argued alongside ecology about whether or not the water was actually legally available or not, because of ecology's interpretation of the in-stream flow rule. The court largely rejected that theory, and then ultimately concluded that it is the county's job to make those assessments when issuing building permits and subdivisions. So I think that's, in terms of whether there's a different opinion about that or not, the Supreme Court's, the majority opinion makes that law.
I guess my question was, I know there's bills in the legislature trying to kind of take us back to where we were before. You know, take the county out of decision-making and say we can just rely on ecology's guidance. That still doesn't affect a junior or senior water right. So if we start giving out building permits, can't people still be, end up in court with their neighbor arguing about whether they have a senior or junior water right?
They could. And I think that there was actually this line of questioning came up during the Supreme Court argument, but in that position you'd be much like any other competing water right users who have the ability to argue about impairment, one person's use impairing theirs, or vice versa. So that's how those would typically be adjudicated if that situation were to come up. It would happen later in time.
Thank you.
If I could say something on that. The question, of course, is compliance with the order, and I don't think there's any debate about compliance. The county needs to comply. The court specifically declined to grant invalidity, which is significant in a GMA case, because it doesn't automatically stop application of county ordinances. The county did that here. Noncompliance does give the county time. This partly addresses what you said, Mr. Brown. The noncompliance finding gives the county time as well. The county has until May to come into compliance. It came into compliance probably earlier, it was my point, than it needed to. And with respect to what the risks are, you're right. And what I said, good luck, meaning the county's not providing the same level of assurance to somebody with a building permit today in the state of Washington based on an exempt well than would have existed before Hearst. And the difference is well, and I agree with Mr. Casilius, you are in a little different position in the sense that this was your case in Whatcom County. It was a non-compliant finding, but it was your case. The difference here is that people would have in some other counties, people might have a choice whether they wanted to take that risk themselves and go ahead, or whether they have the opportunity or not. And I'm not really, I'm not debating the wisdom. I'm not advocating for one side or the other here, frankly. I'm just pointing something out that I believe, in my legal opinion, is the case. So in other counties, there is choice. In Whatcom County, there's not. But make no mistake, there is no choice with compliance. We're just talking about a question of timing. And by the time the compliance hearing comes, the county has to have a compliant ordinance before the board. So we're really not disagreeing about anything with regard to that.
I have a question for Chuck. You mentioned on a 500 gallon a day usage that approximately 100 gallons of that would be something that you would need to mitigate. What is that based on? What's the formula for that? How does?
Well, I was
that just a
I was kind of throwing out some numbers, but to give you a rough idea, I was looking at an American Water Works fairly detailed study of indoor water use just the other day, and a very extensive, very well done study. They determined that typical water use, specifically for the Seattle area, indoor water use now, I'm relating this to indoor water use, was about 80 gallons a day per person. So if you kind of throw that in there, you got about, what that comes out to about 200 gallons a day for 2.5 people in a house, which is, I think, is the standard that people use. And, you know, I kind of fudged it a bit, quite frankly, with the numbers that I just threw out there. I picked 500 because I figured there's probably a little more use in there or something like that. And the math was easy to do at 20%. The consumptive use numbers come from fairly detailed studies that have been done by the USGS regarding how much is actually consumptive on a month-by-month basis for indoor water use also. And I don't have those exact numbers in front of me, but they range from, depending on the month, in the 10, 12% range up to 17, 18, maybe as much as 20. So again, just to make the numbers easy, I picked 20%.
So if, just to follow up on that, so if someone was needing a mitigation plan to submit, how would that plan be based? Would that be based on the 20% if you were doing that, or?
Well, what I would like to see from an applicant, if they're developing a mitigation plan, is to come to the county with what they think is a reasonable amount of water referenced to, some defensible reference amount of water use. And the same thing, they would be able to dig up the USGS studies I've done, and they could look at it, and they could come up with a number, and they say, well, here's the range. We are going to pick the high number, or whatever, to be conservative, just on an average, something like that. It would need to be, we need to have it documented, it needs to be defensible, it needs to be referenced to
Yeah, that was my
its all
kind of question, is
references.
how would it be
And that data is out there. And there's some good data out there.
Okay, now we'll go back this way. Ms. Brenner. Microphone.
Oh, quick comment and then a question for Mr. Lindsay. I do believe we should have asked for reconsideration of the Supreme Court. It not only would have given us time, but they would have, I guess they wouldn't have had to, but they probably would have given us way more clarity instead of us fudging around trying to figure out what's what. So, and that didn't happen because nobody was interested but me. The rainwater catchment thing that you talked about, I just, for the life of me, cannot understand that an exempt well would be illegal, but rainwater catchment would be legal, since it's the same water that goes from one place to another. And furthermore, rain catchment is not, there's no state law that allows it. Their ecology, the same ones who got us here, is interpreting that to allow us, but there's no state law that says rainwater catchment is legal. And I can't even understand how one would be and another wouldn't. So if you could clarify that, that'd be great.
I'm going to clarify it by saying I totally agree with you. I've had that discussion with the AG also when they explained this policy to me in the first place, and I told them that as a hydrogeologist, I just have this fear of being under oath on the stand, and somebody's going to ask me the question, if you catch this water 3 feet off the ground, does that mean it doesn't, it never was going to participate in the hydrologic cycle? And my answer is, it sure would have. But they do have a policy. It's policy 1017, I'm holding it right here, that does say that that is a viable option. And I think the county needs to make that, let people know that that currently is a viable option for mitigation and for direct drinking water.
What would prevent the same people who love to sue us from suing on that?
Nothing that I'm aware of.
Yeah, so anyway, makes me nervous.
Mr. Donovan.
Yeah, I'm going to keep coming back to the mitigation thing. Just trying to figure out what tools we might have, including the rain catchment thing. But when we're talking a couple 100 gallons, 100, 200 gallons to mitigate per unit, lot, or whatever, we're talking potentially 18,000? How many? I'm looking at staff back here.
8,000. New.
In terms of the lots that are out there that potentially would need to rely on, so we're talking, we could be talking 3 or 4 million gallons a day, not just a couple molecules. That physics isn't going to change. So, and this is getting to maybe the PUD. I've heard this in Skagit County. They're allowing water to be tanked in. Maybe it's the PUD providing that kind of water. People can put storage tanks. I'm not saying this is the way I'd want to rely on water, but what other tools are out there for mitigation besides just rain catchment?
Just a couple things. Before I answer that directly, I want to go back to Bob's comment about in-stream flow rule. We need to keep in mind that the 85 stream flow rule established minimum flows in not just the main stem at a measuring point now that's being used at the gauge at Ferndale, but in most of the tributaries. And so when we look at the issue of impact of groundwater or surface water diversion in those tributaries, You can talk to folks in the room that represent agriculture, trying to get changes in surface water to groundwater, groundwater to surface water. It's, we have to look at tributary to tributary basin, or sub-basin, looking at how to develop new in-stream flow rule that could possibly open up opportunities to make some changes. The other is that, getting back to maybe answering partially your question, Mr. Donovan, Barbara's question of how do we solve the problem? I hope that the state legislature is effective and successful in passing a new law that would take away the immediate impacts of the Hearst case, the decision. But we've got to keep in mind that there are folks that have been working on water supply issues around the county for well over 25 years. And it's, the Hearst case really just brought, put this in front of our face to say we've got a problem here. And that if the legislature is successful in passing a law that isn't successfully challenged after it does get passed, and opens up the door to, issue permits for exempt wells, we hope that we don't say, okay, the problem's solved, it's over. Because there are a number of us, through the watershed planning process and through what we refer to now as the Lower Nooksack strategy under the joint board, have been working for many years on developing this. The answer to the question is, how much water do we really have in the county? And we're starting to put together some plans now to look at opportunities to move water around. To answer your question directly, Mr. Donovan, the options for mitigation, I think that what we really need to look at is, whether the legislature is successful or not, that we really need to start looking at all the water that enters Whatcom County and how to manage it as a system, whether it's connecting the 250 odd Group A, Group B water systems, the half a dozen water districts, the PDs, the City of Bellingham, the municipal systems, and start looking at how to manage and how to share and how to move water around. We've been working for the last 15 years with agriculture in this county, and a high percentage of the amount of water that's used for irrigation does not have water permits, to use it. How do you deal with that when you're looking at the opportunity to try to get water to the lot owners, the people that have bought lots out in rural Whatcom County and trying to get a well? And how does that use of that water compete with agriculture? We need to start looking at all those options and start looking at this as a system. Doesn't mean that some one agency or some group of agencies, organizations, owns and operates all that complete water system, but we have to work together to do it. There are some examples, especially in eastern Whatcom County, or in eastern Washington State, the Walla Walla Basin. They had a bill passed in 2009 that essentially gave them, that group over there in the Yakima Basin, the opportunity to meet stream flows and then essentially throw away Washington water law, not carte blanche, but essentially, and how they can then manage their resources in meeting stream flows and getting the water to where they need it when they need it. Directly, the answer to your question, there are a lot of options in terms of, I know, Councilmember said you mentioned in an editorial, a while back about the PUD has 1 billion gallons of water available, of water rights that we're not using. Yes, we do. We have more than that. But under current water law, we don't have the opportunity to move that water wherever we want in the county and make it available. We've been working with other Whatcom County water districts, some of the cities, for the last few years on developing a water budget, a water plan that looks at all those options, where the water is available, the groundwater model that Mr. Lindsay is currently undertaking, identifying, what the resources is available in the aquifers. So, long answer, but there's no short-term solution, and even if the legislature is successful in getting that law passed, that opens up the opportunity to use exempt wells. We hope that we don't think that that's the long-term solution.
Mr. Sadhu?
I think the Hearst decision is a right solution for the wrong problem. What it has done, that we are here today. I mean, last 2 months we have seen, I think most of the people in the county now know about water rights or wells or everything, which we never heard for last 25, 30 years. And the problem has been there for 25, 30 years. It's not something new. I mean, at least that credit goes to the Hearst decision that we are talking about it. Now, I want to change the topic a little bit, is that one of the mitigation option is water bank. I know it's a little concept which is not easily doable in every place, but I think that we should look at it, and I want to ask this question to Steve. Do you have appetite to put the seed capital of 500 million gallons a year into the bank? I mean, to start the bank, the biggest issue is somebody has to put the capital in, so now you can lend to the other people, or other people can start depositing, So to start that concept, it will be very difficult to get private people, farmers, or other people to come and say, yeah, let's go make a bank. I'm just asking. I don't know the answer. I'm just asking, or anybody else can explain that. Is it possible if, like City of Bellingham has water rights, it could be that Bellingham has 1 million people population, they will still have water. They have that much water rights. And I want to say it because a lot of people don't know these things. So, and same does PUD, right? And all I'm saying is, it is, at the end of the day, it's all community water. It all belongs to all of us. Even we put the name COB or PUD or XYZ, it's for our benefit, for all our citizens. So whatever situation was 70, 80 years ago, we allocated that way, that time. The wise people thought that's a good way to do that. But things change. And it is in the purview of the citizens to rethink those things. So what I'm asking is there a possibility of starting a water bank and be one part of the solution? Not that this will be the silver bullet that solve all the problems, but especially ag sector, which is a hidden issue so far, in the sense that you think that it is possible?
Well, first of all, the PUD Commission has for years made it very clear that the water rights that the PUD holds should be used to resolve problems of water right scarcity throughout Whatcom County, while protecting the water rights that were first acquired to support our Cherry Point customers. That's really how the PUD acquired those water rights initially. But we do have, we are currently using and committed to serving Cherry Point customers for only about 40% of our total water rights. So the first response is the PUD is always open to put, as you say, the first investment into that water bank or that water exchange concept. The question comes to how do you meet current state water law and move that water around Whatcom County? In other words, transfer the use to agriculture in North County. How do you transfer it to agricultural use or municipal use in eastern, in the foothills. That's where the challenge comes. We've been working for some 15 years in trying to move some of our water rights from our points of diversion in Ferndale upriver to help agriculture and help. And so that's where the challenge. But your reference to the city of Bellingham and the question needs to be addressed to them. But until we all agree, the organizations with the water rights are willing to come together and look at the entire county as a system and how we can then move, share.
Okay,
that's what's needed.
So this was a legal question now. Now all the citizens of Whatcom County are actually quite motivated, and does the county council has a pathway that we make a request for an exception? Would it go to ecology or would it go to legislature? Like when we look at legislature fix, I personally feel it's not going to solve all your problems. It's a kicking the can down the road. We will have a partial solution. We will face this thing in another 10 years. What I'm asking is there a pathway to find an exception that if the community, all the stakeholders agree, that we get the exception to be able to transfer some of the water rights? I don't know, I'm just asking question. Is there a possibility of that?
There are layers upon layers of complexity in your question.
Yes.
And it would be like peeling an onion.
I thought you had all the answers.
I never said that.
Sorry.
But there are just a couple points I want to make. One of the challenges with a water bank in Whatcom County and the Nooksack Basin is we have an unadjudicated basin. And so we have water rights, but they haven't been adjudicated, and until the water rights are adjudicated, no one has certainty as to what's available. We have a huge senior right that overlays everyone, which is the Lummi tribe's senior right, and that has not been adjudicated. So with so much uncertainty, if you're a banker and you want to have funds, you'd like to know, I really have these funds to lend, right? And the lender wants, or the lendee wants to know, am I really getting something? Am I really with this commitment? And until you have some of those questions resolved, it makes a water bank challenging. I'm not going to say it's impossible. There's pathways, but there's a lot of time and effort that needs to be put into things like that in order to make any accomplishments. Mr. Jilk mentioned that people have been working on these kinds of problems for 25, 30 years, and you can see that we really haven't solved them yet. One small thing I would say, and we talked a lot about things related specifically to the Hearst case. That is what I understood the meeting was. This could be a lot broader of a topic if we were going to talk about all of water. One thing that Mr. Jilk said, and also Mr. Lindsay both, that I would agree with, that the county could do, is to make an effort to look at what the municipalities have, the water districts have, the water associations have, maybe bring together a task force if you really want to try to look at this option at a local level, because some of those jurisdictions, including associations, may have water that could be used for mitigation in a given location that could solve a problem here or a problem there. And you won't know until you start to get into it, because each one of these municipalities and associations, they stand alone. They're not really accountable to anybody but their own ratepayers. But if someone like the county were to say, hey, let's get together and see what you can do to help solve these problems by making water available in places where they could be used for mitigation, both for individual well owners and perhaps others, I think the county could make a difference. in that regard. If you look at the Coordinated Water Supply System Plan, which you adopted about a year ago, the jurisdictions of all these different associations spread out over most of the county. And they have their own water rights. And yes, there are challenges with moving them around, but they're not always insurmountable, and you don't know unless you really put the effort in. I suspect you could make some headway.
I'd echo that. I think there are some challenges, but that I wouldn't say it's impossible, and there's opportunities. I do think the current state of the law makes some of this more challenging, and I wanted to grab the mic for a second to highlight that's, I think, some of the legislative effort down in Olympia is to try to address this issue, the mitigation side of things, to try to free up the controls, both if as an individual, if you want to adopt a mitigation plan for your withdrawal, or on a more regional basis. There's some effort, and I'm not going to speculate as to whether that will take hold and will actually be adopted, but that's at least some of the energy on this topic is meant to address the mitigation side of things, and in order to try to free up that as a tool and make it more accessible. So that may become an easier task if the legislature takes action, but it's too soon to tell.
Okay, we'll go back to this side. Mr. Brown? Oh, we got more? Okay.
Just follow up back in 2010, as negotiations were ongoing for two different test pilot settlement concepts. One was referred to as the Bertrand settlement, and the other was the Middle Fork settlement. And those were negotiations to try to reach between certain entities, the city of Bellingham is one, and the tribes, to try to reach settlement on water claims by the tribes in those two different areas. As that was ongoing, there was an expectation that both of those would be fruitful negotiations, and so there was a question as to what happens next. And there was a group that worked together, Whatcom County staff, City of Bellingham staff, PUD, agriculture, in coming up with the what if, what happens next, and it was the idea of moving those negotiations down into the main stem of the Nooksack. And we came up with a concept called the Lower Nooksack Strategy, and that had 5 elements, and I won't go into all 5, but the third was coming up with a water supply plan that would identify sources and uses for all, and then tie that plan to land management. So your comprehensive plan, the city's comprehensive plan, the county's comprehensive plan, and try to identify what are, based upon the land use, the zoning, and the use, what water would be needed and where would you get it from. That plan was brought actually to the county council to get funding in support of that, and the council decided not to move ahead with that. One piece of that was the Coordinated Water System Plan, and you did just complete that and approve that. But starting in 2015, through discussions with a couple of the cities, City of Bellingham, City of Linden, City of Ferndale, City of Blaine, and some of the water districts, agriculture, the PUD decided to facilitate ongoing discussions and to bring that concept forward again. And so for the last, 16, 17 months, there's been a very informal staff represented group have been meeting to start looking at those same kinds of options. And we've been leading the facilitation, like on the groundwater modeling. We're looking at working with the Lummi Nation on looking at an infrastructure concept as to moving water out of the main stem to some of the tributaries. We've been able to get some grant funds from both the State Department of Health and Bureau of Reclamation to look at things like a drought contingency plan tying agriculture use and to sources. We've used the Coordinated Water System Plan to identify water associations, water rights, availability of water, and so forth. So there's a number of studies, efforts, planning, coordination, collaboration, discussions going on, moving towards that concept of, okay, where do we get water, how much water is available, and where is it going to be needed, and then start looking at things like water bank, water exchange, and even potentially the infrastructure, piping, pumps to move water around. So.
So I just want to make two comments, and you can, and if I'm wrong, if one of the legal minds here could contradict me, but if I'm right, then there's no comment necessary. One is, I understand that one of the challenges about water banking is that it has to be mitigation in the same area. So part of the challenge of having the PUD with its extensive water rights is it doesn't help somebody in Lyndon or Kendall or anywhere else upstream, because the mitigation has to be at the point of use. Correct me if I'm wrong.
The mitigation needs to be provided at, that's one of the, and you heard in the video the discussion of the Foster decision and the emphasis placed on the limitation of that tool and the difficulty of doing it. I think some of the mitigation tools that we've been discussing today, though, would envision delivery of water, the piping, that sort of thing. They're designed to address that issue. So
But that's the fundamental challenge is,
correct.
If your point of withdrawal is in Ferndale and you're trying to mitigate in Lyndon, someone has to build a pipe from Ferndale to Lyndon. So.
Yeah, but that's correct, and that's one of the reasons that pipeline has not been built yet. But on the other hand, if Bellingham has 125 CFS water right from the middle fork of the Nooksack, which it claims to have, and it has a paper right that says that, rather than diverting it from the middle fork, that water could be transported down the Nooksack River. There's a statute that allows the river to be used as a conveyance and taken out downstream, not just by Lyndon, but by others downstream. So Bellingham is actually in a better position than the PUD to provide water in that sense. And the fact that it comes from Bellingham, it's still the same river system, the Nooksack River, so it would definitely be legally possible to do that. There just has to be the will to do that.
So my understanding is that the water right would be calculated, the mitigation value would be calculated based on the amount of water going into the stream, the top of the stream, less evaporation between where it's going in and where it's coming out. So let's assume 10% evaporates from the middle fork to, say, Lyndon, so then you get 90% credit. The challenge I understand, though, with that is, while that I think is valid for the Nooksack, it doesn't help the tributaries of the Nooksack because the water's not being put in the top of the tributaries.
That wouldn't, but there are other potential solutions. Let me make two comments on that. One is, on a very small scale, Lyndon is doing that now by having worked with another water association, purchasing its water right, putting the water in Cam Creek, taking out of the ground, putting it into Cam Creek surface water that helps with in-stream flows, having it go down into the Nooksack River and taking it out at its point of withdrawal on the Nooksack River. So solutions like that can work. You may have heard that Birch Bay Water and Sewer District is exploring a deep well. There may be opportunities for deep wells in certain locations that don't have adverse effects on surface water because they're so far down with aquetards and near the sea that there's no chance for impact to in-stream flows. Waters like that could be used for mitigation in tributaries. But again, it all requires building infrastructure to do that. And, you know, there's, as I said earlier to Mr. Sadhu, there's layers on layers of complexity. That doesn't mean it can't be done. I'm sure there are layers upon layers of complexity to send a man to the moon and ships to Mars, but it can be done. It just takes the effort, you know, it takes the somebody to show the leadership to get it done. That's been one of the challenges because there's a funding issue. These things take money. The county traditionally is not a water, it's not involved in water. This has sort of been foisted upon you now. And Hearst has put it to a point. But you don't have water rights, really. I mean, you may have some as a property owner, but you don't have water rights. You don't serve people with water. So this is a little bit new to you, but you have a lot of constituents here who are affected by the Hearst case. And now the Supreme Court says, hey, this is your baby. You guys have to figure it out. So like it or not, unless the legislature changes the law, I think you have to try to figure it out and start getting involved in some of these discussions that Mr. Jilk's been describing, perhaps in a way you haven't been in the past. That's just my take on it.
And I think, you know, personally, I mean, I've been involved in these discussions, and the big barrier is always the price tag of building the infrastructure. Yeah. And the second the barrier is the fact that a lot of people who have water rights are unwilling to open them up to reallocation, because that brings into question whether they were ever relinquished in the past and whether they are in fact valid. So, but the one question I did want to make sure we didn't leave tonight without addressing is, I know, you know, there's been an opinion as to whether we should or should not have gone into compliance once the Supreme Court ruling came down. The question that hasn't been discussed is what would the consequences have been to the county, or what could they have been, because ultimately we still are subject to how the Growth Management Hearings Board reacts, or Hearst et al. Reacts, or the Supreme Court. But if we had not put the moratorium on and said, everybody just keep doing what you've been doing until the compliance date, what was the risk to the county and the risk to the people who had built the properties based on us telling them, just go ahead, go right up until the compliance date, and then we'll suddenly go into compliance. So I think it's a question that needs to be answered.
Are you asking me that question?
Well, I'd like to start with Mr. Casilius first, perhaps, because I know he spent a lot of time on that particular issue.
So I think I'm going to be just a little careful here, because I do think when you talk about what's the risk and liability questions and things like that, we're getting into the privileged and confidential advice that's been provided to the client through executive session that I don't think is appropriate for me to be breaking that privilege in a public session. I think it's fair to say, without maybe try to answer your question to some degree, the issues of compliance or not. First and foremost, I think the county has discretion in terms of taking action to address the compliance. And there's certainly nothing that says thou shalt wait until the very last possible minute to do it. So that's just sort of the frame of reference within which we operate. In terms of the timing of that, I think I've already mentioned there's some difference here in terms of the nature of the decision as to the interpretation and the debate over, and this is quite frankly, I think what's prompting some other counties who would not otherwise have to deal with this to look into it and actually take action, has to do with the court's discussion of the statutes that govern the issuance of building permits and subdivisions. That makes this just different than the garden variety GMA case. In terms of the invalidity you've talked about as well, and I agree, I think that's out there also. So there's a variety of things that kind of get thrown into the mix of that evaluation, but that within that, then the county makes a decision as to how to proceed, and I think certainly was within its right to proceed as it did, but I don't want to go as far as sort of now weighing what's the litigation risk, because again, that's attorney-client privilege.
And I think the important thing there is that counties that were not subject to this rule have also decided to take the same action we did.
Correct.
And I think that's the best tell of the necessity for doing this, is that if you don't have the sort of Damocles called the Supreme Court ruling hanging over your head and you still decide to do it, then obviously there's either a lot of liability to the county to not doing it or to the citizens.
And I guess the last thing I'd add is Councilmember Weiner's observation that there's another issue out there of proceeding and what happens when somebody moves forward and the property owners that move forward with development in the meantime. If you wait and wait and wait, and more of those are approved without thinking that through with the lens that the Supreme Court provided, there's that to assess as well.
Mr. Mann.
My question was so minor, and in the interest of time, I'll step by. Everyone else was talking about high-minded policy stuff, and I just really had a legal, technical question, so I'll just yield. It's fine. I don't think we got a lot of other stuff on our agenda, so.
Yeah, I was glad to hear Mr. Jilt talk about the Lower Nooksack strategy. He and I were on the watershed management efforts for 20 years, and it's been in the works. I guess I'd just like to have a sense of, as we talk about, moving water around and sharing water rights and all that, it sounds like that's not going to be a quick fix for anybody that wants a building permit in the next 6 months or perhaps the next 2 years. How important is it for all those schemes to move forward for either ecology to come in and redefine the in-stream flows, or for someone to at least define what the tribal water rights are? Can we move forward with any of those without new in-stream flows or definition of tribal water rights?
I think that if you have any expectation, and I don't mean the county council, but if we as a community have any expectation that we would establish new in-stream flows, we better continue to work on those efforts, because at some point we hope that we will have enough information available on what the, where the water resources are, groundwater, surface water, what the interconnectivity is, and what the habitat in the tributaries especially need to be to satisfy the tribal claims in terms of protection for in-stream flows in salmon habitat. What that all that data is, we need to make sure that we have before we get ecology, the tribes, our landowners all agreeing on how do we move forward. And if we stall on any of that, we're never going to have a solution, whether it's out-of-stream needs or in-stream needs. And ultimately, unless we do have a full adjudication of tribal claims, the best approach, I think, is to develop a good negotiation on what those claims are, what the tribes will be satisfied with, and then how that same amount of water in stream, how we can make sure that out of stream needs are being met. And at this point, at least our discussions over the last few years with the Lummi, they have that interest in mind. And again, I can't speak to the success or lack of success in the Walla Walla Basin, but in the Walla Walla Basin, the tribes, the landowners, the counties, the water districts came together and said, we think we can come up with a plan here that we can all agree to. Yes, the basin was adjudicated, so it made it easier, but at the same time, the adjudication really just pushed that group together to find a solution. Because all adjudication really does is says, here's what the tribes get. Now, figure it out. And so, yes, I think we need to continue to support those efforts, whether it's the groundwater modeling, whether it's the water budgeting, whether it's, whatever it is, to come up with a long-term solution.
I think we need to be strategic about it and understand what is it we're trying to achieve and what's the real purpose of in-stream flows. In-stream flows have a lot of benefit, recreation, aesthetic, and all those things, but really what drives it is fish habitat and the in-stream flow needs for fish. The Lummies, which have the senior right, have two types of water rights. One is called a winter's right, which is an out-of-stream consumptive right that goes back to the date of the treaty. The other, however, is a right to fish and have fish in the river that goes back to time immemorial. And it's that right that will drive the in-stream flow requirements. My point has been over the years, rather than sitting back and waiting for it to be defined for us through the tribes and their adjudication, we should be more proactive in trying to understand what those in-stream flow needs are for fish and get some good data and set the stream flows at where they need to be. Make decisions, some compromises may need to be made here and there, obviously, without extreme uses, but we need to look at it through the lens of what is necessary for the fish, because that's what's going to drive it, given what the Lummy's right is to fishing. So I think that needs to happen. In fact, that would be the single most important thing, I think, to moving forward to an overall solution to these water problems that we have in Whatcom County. If we could find out and get some information and actually set a meaningful in-stream flow rule, not an outmoded in-stream flow rule, but a real in-stream flow rule, that would go a long way. One of the things that's happened down south, and I've pointed this out before, Cedar River, Green River, they've established in-stream flows through habitat conservation plans. Those are expensive things to do, but if you get them set, you have certainty that you will not be in violation of the Endangered Species Act. We have threatened fish species in our rivers, so that is a very valuable thing to have for the whole community. No risk of having an ESA violation. If you have that level of information with habitat conservation plan, you will, by definition, almost have set the right of the tribes, in my opinion, for what their needs are. So as a community, we could sit back and let things happen, or we could be more proactive in trying to determine what the needs of fish are. And I think that would go a long way. Now, we're way beyond trying to solve a short-term issue here with the Hearst decision, but your questions have raised significant long-term issues, and I think it is worth thinking about and talking about the big picture.
Okay, I think we're going to go around one more time, then we're going to wrap this up. So, Ms. Brenner?
Just two quick little things. I think it's unfortunate that you guys are put in a position of like, well, did we have to do it right away, or could we have waited till the last minute? I don't think it's either or. I think there was a huge amount of time in between where we could have, tried to work with the Supreme Court and done things and had a lot better understanding of what we need to do. And in the meantime, the people who are already in the system at least could have proceeded. That was the one thing, because I keep hearing, well, we didn't want to wait till the last minute. The council majority did what it did. The other thing is, Mr. Jilk spoke about all these efforts to coordinate, and I think that's really good, but I don't think there's going to be adequate coordination without involving the private well owners, and that is not happening in the function of this body that was put together. It is happening on the planning unit, but they've sort of been relegated to the back seat. So I would definitely, whatever efforts happen, I would like to see way more involvement with the planning unit. Those are my last comments.
Mr. Donovan?
Yeah, it's just kind of tying together some questions I think that have been asked, but I just want to sort of repackage them. So there is this one potential thing we could have done is not had a moratorium. And just tonight we've heard all these different potential things for mitigation, some that would take a lot of time, some that are maybe more immediate. And we're hearing from people saying, just, let us just get a permit and take the risk. So had we, or if we do something where we say, like, you can have your permit, in the future, somebody's going to be able to tell you maybe you got to mitigate. We might know today what it's going to be. We might know a year from now what it's going to be. But that's out on the table. And the kind of, do it at your own risk. I guess repackaging the question earlier, how exposed is the county then, if we do that? Because that seems, that's the worry that I've been hearing since this has been brought up. It's that, well, we can't do that because we're gonna be left holding the bag. Is there a way we can, have people sign waivers or something that say, we'll accept the risk, we assume the risk?
Well, obviously, I'm not your attorney, and
They don't want to answer it.
but
I don't want to put them on the spot,
And
actually.
he's given you advice and here and in executive session that he can't talk about. My point was this. I just looked at the timing of it. The moratorium was imposed very shortly after the Supreme Court decision came out, before people really had a chance to understand what was going on, perhaps. And maybe, and frankly, it was actually, as I recall, it was put on before the compliance hearing was even set. So there's a continuum. You have to be in compliance by May 17th. And should you wait to the last minute? No. And a lot of the water's under the bridge at this point because a lot of time has run off the clock. But my point was that there was no deadline for you to have to impose the moratorium. Your only deadline was to have something in place by May of 2017. This has harmed a lot of people who have projects in the works, and it might have been nice to have had a window of opportunity, maybe longer than they had, where they could have perfected it.
I don't think that's really good, but how about I'll rephrase the question. Do you know attorneys out there who would successfully be able to sue us if we gave them permits and later they found out that they couldn't legally have that water?
I mean,
Anybody can sue anybody.
I said
first of all, somebody can sue you for anything, but
successfully.
But I think they'd have a tough case, frankly, given everything that's known, particularly if you required the individual at the time of signing the building permit application to sign a full waiver that indicated they'd had the chance to talk with their attorney, that they understood the Hearst case. I mean, you've got very competent legal counsel here between Mr. Casilius and Ms. Frakes, and I want to underscore that. I respect both of them a lot. But they're capable, or someone else is capable of writing out a waiver, and then somebody has a choice. They can get the building permit and sign the waiver. I'm not going to say it's ironclad, but I think they'd have a pretty tough case against you for having issued the building permit with their eyes wide open and having had plenty of time to get legal advice before they went ahead.
I think the fact that you didn't say, yes, it's ironclad, we're not going to be exposed, I think, I think that reflects, that's the fear we have.
There's no such thing as ironclad in the law, but I think you'd have a pretty strong position. That's about as far as I can take it.
That's what we thought going into the Hearst case.
Yeah.
And we won on the appeals.
Yeah.
Mr. Sadoo.
Yeah, I was going to say that there's a saying that when there's a fork on the road, take it. And that's what we did. So, I mean, we can belabor this point to the end, and no matter what we do, we are 50% wrong, no matter what we do. So I think the point here is that we do not have water deficit, we have trust deficit. All the stakeholders, there's no building of that trust, like what we talked about, that 25 years we've been working on it, somehow, and it's not one particular person's fault or group's fault, somehow we have not been able to cultivate that trust, like Walla Walla did. And that's important. But I think that one of the lessons I learned is that we all need to really ponder on that is the in-stream flows are real. It's a real issue. Fish and wild habitat is a real issue, or they need some protection. Water is a limited resource, and we must manage it wisely. And water rights are not same as property rights. Why I'm saying this is because we cannot continue in a denial mode and find a solution. We rather get ahead of the curve and accept these things and then work from those assumptions. And that's very important, you know. And another thing we haven't talked about is the population growth. It's a silent thing, but it is like grass growing slowly, and suddenly you hit the limit, and that's what we are hitting. What was 30 years ago, you know, we were working on life expectancy increase. This is the unintended consequence of life expectancy increase. Now we have more people. I mean, you know, these things are real, that population is going to grow. We cannot put a cap on that. No matter what regulation we make, we can't say, well, we can't let population grow. Population is going to grow, and we have to accommodate that. So I think here are points on both sides, but if we just want to argue, everybody got a good points. But what is on the ground, it really matters, not what is on the papers. And, okay, I will stop here.
Mr. Brown?
First of all, Mr. Casilius, I respect the fact that you can't talk about the pros and cons from a county's perspective. And I asked you the question because I knew you would know what the guardrails were, and I knew you'd talk to them to the degree that you could. And I respect that you couldn't go further, but and I also understand that the outcome of any lawsuit in any circumstances is always uncertain. The evidence for us personally is, you know, we lost the Growth Management Hearings Board, we appealed it, we won the appeal. We lost the Supreme Court ruling by a ruling of 6-3. That means 6 of the Supreme Court disagreed with the other. So if 2 Supreme Court justices had moved on to the other side, we would have won the Supreme Court case. So it's always uncertain. I think the only thing it's not a question, but unless there's something else you want to add, the only thing I'd like to leave the audience with is the evidence of the seriousness of the consequences, perhaps, to the county and to citizens, is the fact that we've now got, I think it's 3 or 4 other counties that are not required to, don't have a compliance date of anything, have decided to duplicate what we've done because they see the risks to themselves. And so if they don't even have a compliance date and they're also imposing moratoriums, then I think the risk to the county and its citizens must be pretty significant.
And I don't know if you were looking for a
Well,
response.
if there's something you want to add to that.
Yeah, just to say, I think that does highlight, I think, the uniqueness of this particular decision as compared to other GMA decisions. And again, without getting into which of the counties have it right or not, and because they're lining up on different sides of that issue, I think the one point I'd like to drive home is that we don't have that luxury.
Right.
But that is the issue that's going on out there.
Anything else down this way? Okay, well, gentlemen, thank you so much for being a part of this tonight. We really appreciate it, and we will now move into our public hearings.
Just like to add, if anybody wants job security, get a job as a water lawyer.
Oh, come on.
Okay. We have a few public hearings tonight. Kind of the ground rules are, audience members who have signed up at the back of the room prior to the beginning of our meeting will be called first and will be asked to form a line. If you're unable to sign up before the meeting started, that's fine. You'll still be allowed to testify. Each speaker should state his or her name for the record and will be given 3 minutes to address the council. Council staff will keep track of the time, and they'll let you know when you have 30 seconds left, and then at that time it's time to wrap up. Please speak directly into the microphones. That helps a lot. Don't forget to state your name. So we have, the first public hearing is an ordinance adopting the interim amendments to the Whatcom County Comprehensive Plan and Whatcom County Code Title 15, Buildings and Construction, Title 20 Zoning, Title 21 Land Division Regulations, and Title 24 Health Code relating to water resources. Does staff have anything they want to say about the interim ordinance?
Good evening, Council. Mark Personius with PDS. Just real briefly, just because this ordinance was only in effect for 3 months, what you see here are sort of organizational or format changes to make clear our approach as opposed to significantly changing our approach. The ordinance makes 3 wording changes, including replacing the term permit exempt well with permit exempt groundwater withdrawal to match the wording in the state statutes, and to recognize that a withdrawal could include more than 1 well. Number 2, it adds the term new to clarify when a provision applies to new versus existing withdrawals. And thirdly and finally, it includes a formatting change to better differentiate the regulations governing new groundwater withdrawals from other legal water sources. The only other thing I'd add is, as we pointed out in the transmittal memo in the packet to council, adopting this ordinance will get us another 6 months, which should get us through the legislative session. And I pointed out in there some of the issues, and as I think some of the panelists talked about, there are some bills that are still very active in the legislature to propose a fix to this decision, and so we're very closely following those and working with our legislators to support those provisions, which would both support identifying an ecology's in-stream flow rule as a legal water supply determination for counties, but also providing for mitigation programs and impacts that we can use, counties could actually use to mitigate impacts to in-stream flows that, as you heard from the presentation, currently are not available to us as tools that we cannot use because of the Foster case or the Postema case or the Hearst case. So that's what we got. Thank you.
Okay, with that, we will open the public hearing. First 3 are Dave Uncles, Barry Winger, and Peter Willing.
Thank you.
Dave Uncles. I live in Bellingham. I have a little story to tell. Tim and Lorraine Vandermeulen own a 20-acre parcel on Vedder Mountain southwest of Sumas, served by a well located on a nearby parcel that they proposed to use for domestic water for a home they wished to build. They retained Ed Kilduff of Comesia Professional Corporation, a hydrogeologist licensed by the state of Washington, to perform a hydrogeologist review after the passage of the interim ordinance imposing a moratorium on the use of exempt wells for the provision of domestic water for building permit applications. This review is required by Chapter 241160A5A on parcels for which water is to be supplied by a private well. That study must demonstrate that a proposed groundwater withdrawal would not impair a senior water right, including in-stream flows established in Chapter 173-501 WAC. The ordinance chapter states that the county may require a third-party review by an independent qualified hydrogeologist. Mr. Kilduff conducted a study that concludes that the well sits in an endorheic basin, that it shares with Anderson Lake, a permanent surface water body. The lake surface elevation is approximately 540 feet, and the well is at 590 feet with a water level of 575 feet. The study states, the endorheic basin containing Anderson Lake, which encompasses well ACB 977, contains a perched, isolated, unconfined aquifer. The lake and aquifer could not exist if they were in communication with the surrounding regional valley aquifers. The study concludes, therefore, withdrawals from ACB 977 will not affect aquifers and streams outside the valley where it is located on the northern flank of Vedder Mountain. I sent you this study and some other materials yesterday, and so you should have it. After Vandermeulen's submission of the study to Whatcom County, the county retained Chuck Lindsay, LHG of Associated Earth Sciences, to review Comesia's study. Mr. Lindsay stated, quote, the currently accepted regulatory standard with regard to impacts to a regulated surface water body is 1 molecule, referring by inference to Postema. Mr. Lindsay stated that there must be some seepage and surface water drainage to Sour Creek He stated, quote, "The Comessia report does not provide the information necessary to evaluate the
30
use of
seconds,
well
please.
ACB 977. In response, the Whatcom County Health Department rejected the Comessia study. Postamont, to which Mr. Lindsay refers, does not contain the term one molecule and imposes no one molecule standard. Further, it requires that continuity between groundwater and surface water be established and recommended following the more accurate data set. The drainage conduits on Vetter Mountain from the vicinity of Anderson Lake to Sour Creek are
Time.
ephemeral and consist partially of roadside ditches. Mr. Lindsay's report contains insufficient data to reject Comessia's study. Thank you.
Thank you.
I just wanted to say, it's my understanding that was the one time there was a hydrological study provided, and, you know, it gets political when you decide to have another person who does a lot of work for the county, you know, offset it. I don't know. What if the guy's right and the other guy's wrong? This is what's really bothering me. And
Okay, Barry Wenger, Peter Willing, and then Linda Twitchell.
come on, Peter.
We can't hear you.
Come down, Peter.
Mr. Wenger had to leave and yields his time. He says that he will write a letter later, and I will do the same thing. I yield my time as well. Thank you.
And you're Peter Willing?
Yes.
Okay. Linda Twitchell, Mary Kay Robinson, and Bruce Boyle.
Linda Twitchell, Building Industry Association. I was going to bring y'all water bottles that the BIA
Empty
presented
water
to the
bottles.
legislature last week that say fix Hearst, and I still got them, and someday you'll get them, but that's not tonight here. Following Dave is a good point. My objection to the second interim ordinance is 24.11.060, item B2. I'm not sure what page of your stuff that's on, but it's talking about how you can do a study by a qualified hydrogeologist licensed in the state to show that you will not impair senior water rights, et cetera. And then basically what this says, however, is if county staff doesn't like it, they can throw it out. Or they can hire somebody to come in at the expense of the applicant to prove that the applicant's specialist was wrong. My suggestion would be, you've got to define it if you're going to say the county can basically toss out this study based on a qualified technical review team. Who's a qualified technical review team to go over a licensed professional's work? It would have to include at least one such licensed professional, and I would suggest that should be done on the county's dime, not the applicant's. If you're paying a professional who is a recognized licensed professional to do a study, why would the county staff be able to reject that work? These are people who have what? A bachelor's at Huxley and a few seminars on the subject where we're talking about them basically determining whether a licensed professional's work is correct. Or if the other option here is that the county may require a third-party review by an independent qualified hydrogeologist and that this would have to be paid for by the applicant. Again, that makes no sense. If you're having an applicant pay money to hire a licensed professional, why would you charge the applicant to hire another licensed professional to come in and rip down the first guy's work? You know, if you're going to have two licensed professionals, first of all, if the county's calling it in question, I would suggest it should be on the county's dime, not the applicant's. And who's going to decide which of these guys is right?
30 seconds, please.
I mean, we don't have anyone on staff qualified to do that. Hearing examiner, judge, whoever. If you're going to take it that far, it seems to me again that usually in legal proceedings, it's the challenger who pays. That would be the county to get this through. So please consider that. The mitigation, I also wanted to mention, Mr. Lindsay said 25% of water used in a well, according to the USGS figures, that water would not go back into the ground. Department of Ecology figures that we've seen in their study says 90% gets returned. So if you do start using a figure like that to determine mitigation requirements, please consult the Department of Ecology and see what they tell you about our local. Thank you.
Thank you. Mary Kay, Bruce Boyle, and Jim Hansen.
Good evening, Mary Kay Robinson. I'm the chair of the Government Affairs Committee for the Whatcom County Association of Realtors. First of all, I want to thank you before, Ken, for your resolution to support the bill. Currently, that's gone over to the House, Senate Bill 5239, which goes back to the Department of Ecology. I appreciate the continued support, so thank you for doing that, number one, and hopefully we can make that happen. Number two, if we did have the time to comply, and we have to comply, I get that, can we at least take care of the people who were caught in the middle? Can we at least address the people who were halfway through the process and spend tens, if not hundreds of thousands of dollars so that they can complete that process? And if we have to have a disclosure, disclaimer, then let's do that. But at least let's address that amount of people who have been caught in the middle of this mess. As far as the mitigation plans, two things there. Why is there a restriction to 50%? If someone wants to buy a manufactured home on acreage, why is there a restriction that if you want to enlarge that home to another 50% greater than that, why is there a restriction to that? If the well is 5,000 gallons, why are we saying you can't enlarge the home? That has no bearing. I'm not sure where that comes from. It's not a new withdrawal. Lastly, as far as the mitigation plan, it talks about financial insurance to ensure mitigation measures for the duration of the water use from a lending standpoint, and I don't know too many people who are able to pay cash for the land and cash for the house. It's a very small percentage. So if I have to go and get a loan from a bank to build my home, underwriters don't like unknowns. The financial financial assurance, what does that account for? Because an underwriter is going to have to factor that in. You can't just ignore that. Underwriters don't like to ignore risks. They want to know that you can pay for all that. And how long is that going to go on? Are there increases in that? That's not defined in here. So I think you throw a wrench into any kind of approval process, even with this mitigation. And I won't get into the other issues as far as the mitigation, but that's a very real problem for anyone who wants to get any kind of lending. I can see a lot of underwriters in a bank saying, I don't know what this means, I don't know how much it can be, I don't know if you can afford it, therefore a loan is denied. So we can have a great plan in place and then not achieve the result that we want to have. Thank you.
Thank you. Bruce Boyle? Jim Hansen? And then Laura Sanderson, and then Roger Almskar.
Hi, Jim Hansen, 2418 Kiesling Street. I have to say that you guys have a lot of stamina for these evening meetings. It's getting kind of towards my bedtime. My brain starts to turn to mush. But I'd like to say, first commend you all for your public service. Say I'm somewhat indifferent to this particular ordinance. You could just throw it in the hearing examiner's lap and let it go. Also, I want to reinforce what's been said, that whatever the legislature does isn't going to add one drop of water to the streams or to the river, and that's, I guess, up to you all and everyone who's helping you to try to work towards that. And I agree with Mr. Sidhu that we do need to just get off the legal stuff and put some money into getting something done in terms of water banking, mitigation, changing the ordinances so it make it easier for people to use the water they have, doing things for water conservation, to help the farmers. But I mostly want to speak about the other element of the Hearst decision that hasn't really been mentioned, and that's about the water quality part. And I know you have the septic systems inspection ordinance before you. And I believe that two places in the Hearst decision we were criticized for not having strong enough safeguards for our water quality. So I would like to suggest that the county go ahead and make those inspections mandatory, but provide funding subsidy for those for whom this would be a financial hardship. And also, I'd like to see the county publicize the availability of the low interest and no interest loans that would be available to do the work to remediate the failing septic systems. And furthermore, I'd like to suggest that this be partially or wholly funded by the imposition of stormwater impact fees for new construction. And I've always had a problem with lack of impact fees, and I understand that lack of compliance with the GMA for a comprehensive plan has been a barrier, but perhaps this would be something we could throw in the mix to help us speed approval of our comp plan and show that we're really serious about taking care of these fecal coliform pollution issues and nitrates, et cetera. Thank you very much.
Laura, then Roger, then Zach Nutting.
Good evening, Council. Laura Sanderson. Thank you for the little video that we saw in the beginning. I have to agree with Barbara. It was quite biased, and that was unfortunate. But one of the things that I saw in that was, the diagram of the 1% that is, it seems to me, there's such a huge effect on a small group of people for this one little slice of the pie. Why are we not looking at smaller changes in the rest of the pie that would affect everybody else much less? It just doesn't make sense to me. So I wanted to share a conversation with you, an unfortunate conversation that I had on Monday. After I finished reading the hydrogeology review done in February regarding the Vandermeulen 20-acre parcel, the report is extensive, 24 pages, and includes everything that anybody asked for. And they were still told it's not good enough. That same afternoon, I got a call from my son who went to 3 different banks to get a loan on his land. And he was told, we can't make any loans on land right now. You don't have a water supply. So he said to me, Mom, you're in real estate. You're working on these things, right? I can only do so much, son, but I've been filling you in on what you have to do. So he said, if I do everything that they require, I'll be okay, I can build, right? Sorry, son, I'm afraid not. Because apparently, even if you do every single thing they've outlined you to do, it won't be good enough. Based on the Vandermeulen hydrogeology review. And he said to me, that's crazy. Pardon my language, that sucks. Yeah, son, it really does. And I'm sorry, but I don't have anything else I can tell you right now. I can't tell you how many people I've had to say that kind of stuff to, and it's still very difficult for me. And then I heard Sat Paul ask the question, is there a path for finding a way to transfer water rights? Make one. Everything that has ever been done, somebody started a path. Make one. The first time I spoke here, I asked you, do your job. Yes, it may take a long time. Yes, there's lots of layers in the onion, but make a path. Find a way.
30 seconds, please.
If Bellingham has enough water for the rest of it, why don't we do something with that? And my last comment is I'm not quite sure why, Mr. Brown, you felt like you had to continuously try and justify this council's actions. I think it's very clear that there were other options to the first moratorium that you put on.
Roger, Zach, and then Carly Dethridge.
Roger Olmsgar, president of the Whatcom chapter of the Citizens Alliance for Property Rights. So I'm giving you a 2-page letter. I'll just summarize it. And I think I'll build on what several people have mentioned, including Bob Carmichael, who I respect quite a bit, and Mary Kay Robinson, that if it's legally possible to set up a program to help people who are caught up in the in-between here, as you've heard plenty of examples of, I don't understand it totally myself, but the waiver idea is a great idea. But to me, the other side of that coin is that the stream flow standards are not best available science, period. Mr. Carmichael explained very clearly how it was just an arbitrary halfway through from the extreme, the high to the low. That's not good science. You know, when we're regulating wetlands, we're told, oh, you've got to use best available science. That's what the legislature said. That's what DOE says, but not when it comes to stream flow standards. Forget it. We're sticking with these 1985 numbers, which are arbitrary and so on. So Mr. Donovan mentioned a while ago there was something like 15,000 developable lots in the county. Well, I can tell you from my experience here since 1971, that is a greatly exaggerated figure. Just because you have a parcel number doesn't mean you have a developable lot. And I could show you some great examples. So I've stated a goal here that I'd like to see us focus on here and at the state level. I think we should be allowing more housing and businesses in rural areas, including farms, to use groundwater for beneficial uses at reasonable rates of consumption and so on, as long as those uses do maintain adequate stream flows for anadromous fish during their migrations. And someone else said, it isn't so much the main stem of the Nooksack River, it's the tributaries. That's what we really have problems with. If there are problems, they're with the tributaries, in my opinion. So we need gauges on those tributaries. Right now, there's hardly any. So if you read my whole piece, you'll see I'm supporting doing a better job of getting that information. That's a long-term project. It would take a year or two to accomplish something there, but we do need short-term relief, and we've talked about some ideas on that. I have one client who recorded a short plat in the summer of last year.
30 seconds, please.
Based on using a shared well. So we ended up with two lots. One lot had a house on it, had been there for a long time, and that house was using the well. And now because of Hearst, Planning Department and Health Department are telling us, we don't think you're going to be able to get a building permit on that second vacant lot because it's an exempt well. They said, well, make an application and we'll make a decision on it. I asked the staff, well, would you say that in writing? No, they've been advised by their counsel not to do that. So again, please take a serious look at that waiver idea as long as it's linked to more accurate information on stream flows. Thank you.
Okay.
Zach? Can I just ask a quick question?
Yeah.
Could you just find this part where it says the one molecule standard was not adopted by the state Supreme Court? I thought it was. So you don't have to even answer me now.
I do have an answer. I heard that. I thought that was true also for a month or two ago. I got the decision on my computer screen today online. I did a word search. I put the word molecule in, 0. Okay? That's a lot better than reading 67 pages. So.
Okay.
And other experts have said
I'm not
it's not in the
you're not allowed to
post-summit
keep
decision
talking.
either. So
But-
I think we should ask Mr. Lindsay, he's not here, where are you getting that number, Chuck? Thank you.
Okay, Zach, and then Carly, and then Jay Markarayan.
So, good evening, guys. I'm Zach Nutting. A little refresher course. When I left you guys last time, I was right here begging you guys to do something.
Oh, yeah.
I told you guys how my 4 children, my 5th on the way, is homeless because of this. That I spoke to these gentlemen here. I see some of their faces about getting a building permit prior to buying my property, and was told I could. And then I purchased my property. I sold my house to my lovely 65-year-old mother and proceeded to move on doing the preemptive work. I'm now homeless. I can't build my house. I don't have a house. My mom bit the bullet for me. She let us stay in the house we once owned. She lived in an RV during this time. Well, 4 weeks and 2 days ago, we had that big snowstorm, knocked out power in the Kendall area. She tried to heat that RV with the stove. It burned to the ground. My mom escaped in her pajamas with her bare foot and her dog. She lost every worldly possession she has. Okay, we now are still in the 2-bedroom house that we were overcrowded. My baby is 8 weeks from due. We listened to your staff say that you were premature in passing this moratorium. We listened to time and time again them discuss other options that could have been put on the table as a way that we were addressing this issue. You guys keep going back to this one molecule science, right? Well, I'm forced to remember Newton's, I think it's 1st or 3rd law, on present time, under present conditions on Earth, matter cannot be created nor destroyed. Now what that means is when we drink water, it doesn't turn into magic dust and fly away. Water is water. It's always water unless it turns into hydrogen and oxygen. And when we process it, that's not what happens. We pee it right out. It goes into the ground. When we wash our clothes, it goes into the ground. The term consumptive use is a misnomenclature. Water is never consumptively used. It is only transferred. Okay, and we are a teeny percentage of that you guys have decided we should bear the brunt of that. You keep talking about the legal ramifications for Whatcom County, about having us sign a waiver. Are you going to give us the building permit for free if we sign the waiver? And on the final idea of that, you're our elected officials, our government, our guardians. If someone kicked in the door to my house with my 4 little children, you can bet your ass I'm the first one in that person's way from harming my 4 little children, because I'm their guardian. I'm the person whose their safety is my responsibility, and that is each and every one of you. My safety is your responsibility. That's what you're elected for. And there is a fight right now brewing with the Supreme Court. Your lawyer is here to help you fight that fight. You should be fighting that fight, not attempting to step out of the way and let me fight it for you. That's not fair. You guys realize that it was your mistake that put
30
us in this
seconds,
position.
please.
You could have let us have a time to get through this. You could have made it known to all the members of Whatcom County that you are losing your rights to build on your property. In 6 months, get your building permits in now. And you could have taken other measures to show that you were in compliance. But you didn't. You kicked the can down the road. It's time to stand up and fight. It is time to get out of your chairs, quit hiding behind your desks, and fight. You're not going to go to jail for fighting this fight. You're going to put Whatcom County in a courtroom, a place where lawyers like this will fight your battle, and they're more than capable to do it. Let's see where it goes. Let's fight. You guys should be doing it for us. Thank you.
Thank you. Okay, Carly, then Jay, and then Natalie McClendon.
Good evening, Council. Carly Detheridge with Resources for Sustainable Communities. And I'm here to speak in basically what Jim Hansen had said earlier in deference to the interim ordinance. Ultimately, we do want to see a strategy where we're solving our water problems, because we really do have issues in the summer where stream flows aren't met. And yes, the science is debatable for the Nooksack and stream flow rule. And if the science was improved, I think the rule would probably be more stringent, as we've seen in other areas like the Dungeness. So that's something to keep in mind, but ultimately we would like to see folks that were caught in the middle of this decision come October in the permitting process to get some relief, be able to build their homes, as Mr. Netting had said, and find strategies to mitigate those uses in the future. But ultimately, we would like to see Whatcom County create a comprehensive water budget. What that looks like is, and this is for the Nooksack Basin, how much water is actually available physically? What's the seasonal picture of that water? How much water is actually used in the basin? And there's very little information on that, as we know, with metering data and all of that. And also factor in the yet to be quantified tribally reserved water rights. So that's kind of what we're hoping for before any solutions are put forward. But ultimately, we do want to support the folks that are caught in the middle of this decision to proceed, because it's a really undue hardship. Thanks so much.
Okay, thank you. Jay, and then Natalie, then Jerry Peterson, and that's the end of the sign-up sheet. So anyone else that would like to speak, please come on down.
Hello, my name is Jay Markarian. I live on Jensen Road out in the county. I sit as chairperson on the committee for our Water Association on the development of policy. In the last year, we've spent, there's been 6 or 7 of us that have spent 3,400 hours trying to understand the water regulations in Whatcom County and at the state. We have some of the most forward-reaching policies on how to deal with many of the issues, specifically in the area of how do we work with our neighboring associations. What I want to bring to your attention here is there's something that underlies a lot of what goes on here, and it's not spoken to. And we're seeing it firsthand in our association. It's a recalcitrant position on no growth that usurps the association, and I would say other associations as well, to help people get service, the duty to provide service, and we're seeing this squashed on so many levels. We have 29 shares available, and that's limited by our capacity of our tank, not by how much we pump out of the ground. We think there's probably about maybe 40 or 50 shares that we could sell in addition. But we're being held back by a no-growth mentality, and I see this in other parts of the county as well, where that people are trying to do the good thing, they're trying to use good science, they're trying to manage their resource, and they come up against a no-growth mentality that tosses obstacle after obstacle after obstacle. So what I'd like to leave you with here is, number one, on the issue of mitigation, consider that the average mature cottonwood tree sucks 400 gallons of water a day through its transpiration in the leaves. So if you cut a few of those down, should be good for a mitigation plan. Second item is that if the glacier comes back, will that require a permit? Or will that affect in-stream flows? I think it will. The last point is, I urge you to think of perhaps looking at my water association, and that's the Whatcom Water Association. We would be the first to get hands-on and dirty to deal with this issue. We have people that want water.
30 seconds, please.
Thank you. We have people that want water, and we're finding it difficult to get them water through our own association board. It's just very peculiar. Again, we're forward-thinking. We've gotten great accolades in the state on our policies, our future planning, and our retail service area policies. And I would offer us as a test case to start getting permits issued for the right reason with all the good science behind it. Thank you.
Thank you. Natalie, and then Jerry.
Good evening, Natalie McClendon, rural Whatcom County. I'm also on the Planning Commission. I don't really have any prepared thoughts, but I am kind of disappointed that I didn't hear anything tonight about the number of individuals or planned permit holders that got caught in the enactment of the moratorium. I clearly remember at the hearing when you first adopted it that there was information that you were looking for from the planning department to understand how many permits or how many people were in a difficult position and solutions to that in particular. And I haven't heard anything tonight about how that might happen. It looks like just going to proceed with more time in the same situation. And I'm a little disappointed with that. I was interested to hear what the previous gentleman had to say. I think there's a huge number of people in this county who have information that can share, and I would really urge you to pull people together in some real brainstorming. I think that there's a lot of good information, good ideas, and deep experience from various people, people running rural water districts to, retired people who worked in water resources all their lives. This issue deserves and needs this, the serious work of trying to figure it out. We are ground zero. The other counties may be just as much in need of it, but we're the ones I think are going to have to take the lead. Thank you.
Well, that was a good question. I would like to know, Mark Personius or somebody.
That'll come after the hearing's closed.
Okay, so we're going to get that answer finally.
Evening, Council. Jerry Peterson, Whatcom County.
We've heard a lot of good things here. Barbara Brennan, you said wait until the last minute was one of your thing about, do we wait till the last minute or we go on? The Growth Management Act was written in 1990, signed by Booth Gardner. So we've had 27 years to try to figure this out. And we've done it in various ways. And I applaud those that have worked. And obviously there's much more work to be done. Todd, you're just talking about the risk and whether or not to go ahead or not. And I want to bring up the risk in my profession as a driller, that in the ordinance on page 11, which is 24.11.060, determining the adequacy of water supply for building permit, in section A, prior to the director approval of evidence of an adequate water supply. I'm going to stop right there. In order to prove an adequate water supply, you've got to drill first. And so you have to show quality and quantity. Now, after that investment's made and all the documentation is submitted with a hydrological study and everything, under section A2, the director will conduct a site inspection and approve the proposed well site. Well, the well site's already been done. And so we are now recommending to our clients that we will not drill under strict scrutiny, that it could be changed. And if that were to be changed, that means that it's now on our dime to decommission that well that could potentially have cost $5,000, $15,000, $20,000, and then drill a new one for that client. So we're not willing to take that risk, and we're recommending that they get that site approved prior to anything else. So that is something that needs to be addressed in this, and have that rectified. We don't want to be getting the cart before the horse. So back to the rainwater catchment systems, and Barbara, I completely agree with you. It is a little backwards when you're saying that the water in the ground being pulled from a well isn't legal at that time, but you can catch it out of the sky and hold on to it. And those rainwater catchment systems, they have to be designed by a licensed rainwater catchment system engineer. Now, just the system alone, we're not talking about the permitting costs and the fees and the installation. They can range anywhere from $3,000 to as much as $20,000, depending on the size and complexity of how they're constructed. Now, per the DOE website, on October 12, 2009, they issued an interpretive policy statement clarifying that a water right is not required for rooftop rainwater harvesting.
30 seconds, please.
If and when the department determines a rooftop or guzzler rainwater harvesting systems are likely to negatively affect in-stream values or existing water rights, things could change. So does water rights equal water waste? Now, all these cities in Whatcom County, they have 0% efficiency with 100% waste, compared to a rural home that puts back 90% of what they're using. When a municipality such as Ferndale, Linden, Blaine use that water, it's treated and right out to the Puget Sound waterways.
Time.
I want to see some mitigation where that water is being returned to the source, whether through a massive septic system or whatnot. But that, to me, is a mitigation plan. Put the water back.
Mr. Chair. Sorry, I just had a clarifying question. You mentioned part of the code about drilling and then getting approval. It was an appropriate place to drill. Where was
Right.
that?
I've even spoken with the health department about that, because it's on the driller to do the setback requirements, which we have to be so far from septic fields and drain fields and property lines and roadways. And once we establish that circle, then we get our site. And then when they come out and do a inspection for the surface seal, which is the first 18 feet, then we're off and running with developing a well. Afterwards, once all our understanding is that afterwards is when the site is approved by the director of the health regarding the hydrological study and everything. That's when all that stuff comes into play. And I think that needs to be clarified and rewritten to show that the site inspection needs to happen first.
Would you send me that in writing? Because I think you've got a valid concern. I just want to make sure I understand it.
Absolutely. I'll send it to you.
And one quick, do I have your number?
You do.
Okay, I thought so.
Okay, next.
Patrick Allison, 4825 Alderson Road. I really wasn't going to speak tonight, but
You always say
you know,
that.
I had to. Do you remember when I welcomed you to Water Wars? I said, welcome everyone to Water Wars. And I said, the water is the weapon, but it's not the goal. The goal is growth management. Have you been to Europe lately? The rural areas there are really rural. The cities are compact. It must be beneficial to people there. I wonder why. I wouldn't want to tell you. Thanks.
Hi, my name is Wendy Harris. I'm one of the Hearst petitioners. And I'm really confused by this concept of we need a Hearst fix. We need a fix. Hearst didn't do anything. It didn't create new law. It simply upheld the law that already existed. And you were all on notice of this. You were all on notice that we were having water problems. You were on notice we were having water quantity problems. So, you know, you can keep on using us as a kicking post, but it just doesn't make very much sense. There's a lot of things that aren't being addressed. You know, we're hearing a lot about protecting the rights of people who bought property and they just want to put in their well. We're not talking about the rights of senior water users. And that's kind of ironic for a county that values property rights so highly, because essentially what we're talking about is allowing junior people to come in and steal vested rights to use water that belong to other people. And that concerns me, and it should concern you. And if you're going to be a guardian for all the citizens out there that want water, you need to also be a guardian to all the people who have vested rights to the water. And that includes the fish and the wildlife. So I urge you to consider that. The other thing that's not being talked about is just the inherent risks of buying property when you have to put in a well. You know, when you have to do that, you're always at risk. You don't know what you're going to find when you drill. You don't know how far down you're going to have to go. You don't know if you're going to hit something unexpected or what kind of water return you're going to get. And we know, if nothing else, putting growth aside, just because of climate change, there's going to be less and less water available. So we have to factor everything we're doing into a climate and a situation of where there's going to be less and less. And that's why it really concerns me that not one person has mentioned the connection between what we're doing with these exempt wells and groundwater and the CARA provisions. Right now, the council's working on the CAO. The CAO involves CARA, critical aquifer recharge areas, and they overlap. And one of the things we know from the CAO is that you have to focus
30
on
seconds, please.
ecosystem functions and values, and we're not doing that. So I'm very concerned when we talk about mitigation, because there's no such thing as excess water in an ecosystem. So this idea we're just going to suck out all this water and keep it in a cistern, you better take a close look at what impacts that's going to be having on those ecosystem functions and values, and nobody's doing that. I agree 100% with what Carly said.
Time.
In terms of we've got to have a water budget. We've got to know it's there. We need conservation, and maybe we need to reprioritize how we're using water. But, you know, we've got to deal with the fact that there's no more water left. Thank you.
It's the end of the world.
Well, that's a hard one to follow. My name is Sue Croft. I'm from Bellingham. I just want just a really quick one, because everyone says everything already, but just so everyone knows that banks will not loan on a rain catchment system. So I found that out through my son, who from People's Bank, and then was told by other people that it actually has to do with regulations, and it's not a reliable source of water, and so banks will not loan on it. So you have to be basically rich to be able to build your house, because you're going to have to pay for it without financial help. Okay, thanks. Bye.
Hello, my name's Ed Kilduff, and I'm a resident of San Juan County, not Whatcom County, but I have clients here. I'm a hydrogeologist. I wanted to expand upon a couple of points that have been made by other people already. One is the opening comments by Bob Carmichael, where he talks about the in-stream flows being set at the median level. I've seen them set at 75% of the wetness in a stream, or the flow in a stream, or even higher. Most of the variation in the flow in a stream is not due to groundwater, but it's due to precipitation. And so when things are set at 50%, the median, or 75 or whatever, and the in-stream flow is not met, and you're asking groundwater to make it up, you're asking groundwater to make up for something that is caused by precipitation. So that's one point. The other point, I think, was made by Dave Onkels when he was talking about postema. I know you're being told what postema means, that it's the one molecule rule. If you read postema yourself, what I read is that it's a conflict between two different sets of data, between modeling data and between actual field measurements. And in that specific situation, the Superior Court said use what they considered to be the better set of data, which is the modeling data. That can be arguable, but basically postema was a conflict between two sets of data, not a general rule to model everything, and not a general rule to use one molecule for everything. It was simply resolving a conflict between two sets of data. That's it. Thank you.
Anyone else like to speak to the interim ordinance? Seeing no one, we will close the public hearing and turn it back to council. What's council's wishes?
Well, I'll move approval just to get it going.
Okay, we got a motion. Do we have a second?
I'll second.
Okay, we have a motion and a second. Ms. Brenner.
Yeah, first I would like to get the answer to Natalie's question. How many people had already started in the process when the moratorium was passed?
Well, there's a lot of different answers to that. That's an onion too. There's people that were in the building permit process. Those folks who had completed those building
How
permits
about
ahead of time
anybody
were
who was
done.
anywhere in the process to build a single-family residence?
Like I said, there's the building permit folks, and then there's subdivision folks. So there's two different classes of those. I think altogether, we're probably talking about all of those would be in the several hundreds.
Total?
Yeah. And
Just several hundred?
Those folks, yeah, the vast majority of folks, right, probably at a minimum 10,000 parcels that are undeveloped parcels that
Right.
have no development on them or no well on them, are going to be subject to the Hearst decision. They haven't come in for a building permit. They
Right.
haven't come in for a subdivision or anything else. They haven't triggered that process yet. So the hundreds of folks who have somewhere in their process, those are the folks that we have been working with, the health department and PDS have been working with over the last 3 months since council adopted this ordinance and this path. They were given a path to comply with the Hearst case, or the Hearst decision. We've been working with those folks to find opportunities for them. We have learned a few things in the last 3 months. In general, I can't speak to specifics about particular permit characteristics, but in general, if a new withdrawal is going to be subject to, or new well is going to be subject to the new regulations and the Hearst decision, if you had an existing withdrawal, you have a little bit more flexibility if you had a withdrawal that was in place prior to the Hearst decision. So, and again, there's lots of nuances to that about what kind of use was it? Was it a legally established use? What kind of water use was it? Was it domestic or undomestic? Where you were in the process.
But
We are working
all
with
of
those
them,
folks.
we're talking 200.
I think it's several hundreds. We're in the hundreds, but it's not a great deal more than that, no. So, and we encourage those folks to come in, talk to PDS, talk to health, figure out where you are in the process. We'll help you. We have been helping folks over the last 3 months through that process to figure out if we can find a way, an approval path for them or not.
Well, I move that we allow everybody who's in that process, the several hundred, to proceed and complete their process, sign a waiver so that the county wouldn't have liability, and go ahead and finish, building their homes or getting in their homes.
Second.
What? I can't hear.
Zach, come on.
We can't hear you.
No, we don't have dialogue during.
Yeah,
And I'm sorry, but since you want us to sign a waiver, taking all legal responsibility away from you, shouldn't that make us not have to pay you for that?
if the legislation comes through, you won't have to worry about that anyway, and if it doesn't at this point, I just want to get, okay, you know what?
I've been at every place.
Okay,
Zach, stop it.
order, please, can we have order in the chamber?
We got to start somewhere. I'd say let's do this. Who knows,
We have rival motions.
You have rival motions. Are you, unless
We
you
have rival
propose
motions?
specific language, if you want to propose specific language as an amendment,
That's my specific language.
where does it go?
As an addition, it's not a instead of, it's an addition. That those people, those very few people comparatively speaking, but that's just me editorializing, those people who have already started the process will not be affected by the Hearst decision and will be allowed to finish their single-family residence.
I'll second your motion. I think you need some more detail there, like how you're going to define in the process, but I'll second your motion philosophically in principle.
Okay, well, I'll just say that they've already, in step one, they've already come through step one of the process, and I don't know. That's as far as I can go. I want anybody who'd already started on that before that decision to be able to finish what they started.
Does owning the property count as being in the process?
No, no, going to the county for permits.
So
What does that
so if they had like one permit or one conversation at the planning department, I'm in support of this, but I can tell you right now,
Yeah.
you're gonna need to get you're gonna need to be specific about this if you
Well,
want to
you're
put it
gonna
in the
help me.
code.
Find the language I tried before.
You're gonna help me be specific. You're the guy who knows about building more than me. You're gonna help me be specific. They've already started the process. That's what the county says all the time, started the process.
All right.
Gave you some language.
I support your intent.
Let me just ask staff, does that motion, would you know how to enact that motion based on the language that Ms. Brenner just provided?
Nick is going like this, and I'd like to know why.
But based on the language that we wrote up.
Well, if we're gonna do it, let's do it right.
I know.
All I'm saying.
I think it seems simple to me, clear to me.
I'll defer to Titus to help explain kind of the legalities of that, but in general, we already interpret, with Titus's help, the particular situations, the implications of the Hearst case on folks who are in process. And that's how we are helping those folks through process and figuring out, based on, the subdivision law, the building permit laws, the water withdrawal laws, and the water law, if their characteristics fit or don't fit. And we are already applying those interpretations.
I'm only
I don't see
talking
anything
about
new on
the
top of that.
permit exempt well. That's all I'm talking about.
That's what I'm talking about.
Yep.
Yeah.
That the permit exempt well portion will be allowed for those who have already started the process to get permitted to build a single-family residence. How's that?
I'm gonna defer to, if staff thinks they can interpret our motion here, that's fine with me.
Okay, that's it.
Okay, Mr. Sadhu was first.
I think there are several things. One of the things I want to clarify that when we discussed this 3 months ago, I did bring it up that why do we need a second hydrologist to verify the first hydrologist's findings? And on top of that, that the person has to pay for both of them. And the question, I think, is still, I'm asking the same question, that when you have a licensing authority, the person goes to the state, has certain qualifications, has so much experience, like a professional engineer, you go to an architect, you get a permit, building permit. You have to go to a structural engineer to get your drawing stamped. Even if you have done the trust yourself and you know it's safe, they still say, no, you go to some engineer and he puts stamp on it, then it's acceptable. So it should be the same principle. it is hard as is to find first hydrologist who would want to undertake this study under the current conditions. One thing I just want to remind everybody, that post-ma or other things, they are constitutional. They have been passed by the Supreme Court. They're part of our law, and we must obey that. So we cannot just say that or ignore that. So that is a caveat we must understand, because there's a lot of information being floated out that, that council is making some laws, that we actually fought that case. We actually spent your money to continue to do what we wanted to do. We lost that case. We don't have a way that we can wave a magic wand and say, well, we're going to follow this law. We have limitations on us. But that is something, and the other thing is that we did discuss 90 days ago that we should have a handle today on this several hundred word, because the whole idea was that we will have created some kind of categories, because this is not a simple question. I want you to understand, Council Member Brenner has said that let's just approve, like it's not that simple. But we must know what are the criteria. There are 3 or 5 conditions to meet if you applied for a permit, if you got your short plat, if you got your well was been approved by health department. There are certain, I should say, steps or goalposts in that process. We must define those so that you cannot put one person against the other. The guy's going to come and say, you gave it to him, why not me? What is an answer to that? Because, we must think through this thing. It's not Me Too clause. We should be, and this is where I would like the staff to come up with. I think we were looking at 3 or 4 different categories of people. If we have done this much work, they are priority A, and they have this much work, they are priority B or C or D. And we should say, okay, if you are in priority A, no problem, come get your permit. Your priority B, you need to do 2 more things to do that. There must be some criteria. And I think that 90 days is a long time for administration to come up with something that, okay, it may be wrong. Like I said, we cannot be perfect. Let's go with something which is 70, 80% right, and start giving some relief to people who are caught in between. Because 1,000 wells are not going to make the fish or in-stream flow or anything. On the ground, 1,000 wells, it does not matter. So I'm in favor of doing something, but I'm not in favor of just saying, well, let's give everybody who is in the process. It's not defined. It will create a chaos, and people will be fighting with each other, or they will be fighting to their own government. That's not the way to govern.
Mr. Brown.
Well, I'd like to respond. He's claiming he's talking about my motion. It has nothing to do with my motion.
For quite a while.
I'm going to defend your motion.
Thanks.
So there's a couple of things with the ordinance that we're looking at that I would like to have further discussion with council on. In particular, I was disturbed that a hydrogeologist was hired, and I gather he was licensed, and then that another one was brought in to challenge his work. And my concern is that we haven't got a threshold as to what triggers the desire to challenge that. And I think that's a threshold that should be. It should be a threshold that the county has to have good cause in order to challenge. In order to challenge one hydrogeologist. The other
excuse me, Mr. Brown, but we are discussing a specific motion at this point.
That has nothing to do with that.
So let me show you the connection.
Okay.
My connection is this, is that there are several things in the ordinance that I think should be discussed in executive session, and I would like to propose that we take Ms. Brenner's proposal and the questions that I have and push them into executive session so we can make an informed decision on them.
Are you making a motion?
That's my motion.
To go into executive session?
No, not now. Because
Okay.
I'm not, no, I think these are issues that need to be handled in executive session.
Ms. Brenner?
Both the comments from the two council members who just commented really don't have anything to do with my motion. I say go ahead and bring those forward on the people who are not in the process yet and will be getting into the process, and I will probably support it. But I'm getting a little irritated, so I'm going to have somebody more professional speak.
I don't know about that. I'll speak to the motion, though. I mean, I did try to come up with some language a few months ago. That might be a starting point for defining what is in the process. And I agree, it's been a long time. I'm hearing Mark saying we're trying to work with people, but I'm also hearing a lot of people on council saying, what can we write down that these are the people that we're going to say, and we're taking a legal risk. I think we understand that.
Well, they sign a waiver.
But I
for
would
now.
say, in addition to the way that Councilmember Brenner's proposing this, that then, yeah, it's either a waiver or there is a recognition that mitigation might be required. And I will dig up the language from before, but I threw out a really long list. I think it was too long, just trying to come up with, what adds up to those 100 or few hundred people that they've done their critical areas assessment, they've drilled the well, they've already been in part of the permitting process. That we can define this in the process bit, but I think we also, to respond to your point, that to try to be in good faith with the decision, also saying, you might have to mitigate, and that might be that's a risk that we're going to write down that's there, and you're going to accept that. And I think that's one way we could maybe make something like that work.
Except that I believe the people who were in the phase of the process, not who had just gone in to talk, but the people who had actually applied and gotten paperwork or whatever to fill out, those people, in my opinion, were vested before that decision. And I believe that those are the people that should get to proceed and finish with a waiver for now. Hopefully the legislature will fix the whole thing. But, yeah, that they were in the process, they had already applied. And that means that they had gone in there, they had gotten, it wasn't just a conversation, that they had gotten paperwork, and that they were, paying for something. So, they're already in the process.
All right, you've persuaded me already. You gotta work on the rest of them.
Mr. Sadhu.
This is a question for the staff, that when you say that we are working with folks, how many permits have you issued in last 60 days?
0.
Has anybody qualified under your conditions so far?
Yes.
You have an idea, 5, 10, 20, 50?
I don't know, no.
Oh, come on, it can't be that many. Somebody would know.
I don't know how many on the tip of my fingers.
Well, they didn't get it with permit exempt wells.
So Tyler Schroeder, Deputy Executive, I want to try to provide a little bit of background and understanding to the conversation that we're having. Tadas may jump in and may want to start, and then I can provide some background.
Sure. So I think and this is about sort of the process that the county has applied to applications that are in process, so to speak. And really what we're focused on here, because I think there are several criteria, and so it's very hard to talk in the abstract because each one is case specific. But in broad terms, just to speak about general categories, again, we could put the new applications to the side here because those are governed by the Hearst decision.
Wait, when you say new application, do you mean after the Hearst decision?
Correct.
Okay, I'm not talking
So
about
that's let's just put that over here. I think, as Mark said, the existing withdrawal piece, in general, there's more flexibility offered to people who have an existing withdrawal. So you'll have a situation where you have a building permit come in for example, a subdivision that's partially built out that already has an
existing one.
So that's in general, there's more flexibility. The second interim ordinance includes some revisions to clarify that intent. That's the way it was always intended to be applied, but the language of the new permit exempt withdrawal, that's what it was intended to capture and reflect that intent a little more clearly. So that's another group there. I think, Councilmember Brenner, you talked a little bit about vesting. So vesting, really, all we're talking about here are subdivision applications and building permit applications. And as Mark said, I think the county has processed building permit applications that were complete and filed prior to Hearst. These regulations do not apply to those applications that were filed prior to Hearst.
Well, when you say applications that were filed, I'm talking about the people who did their critical areas assessment, who did all those things and spent money doing those, all kinds of permits. So I don't know if you mean, that's what I mean. To me, that's the start. Not that they already put in their well necessarily.
So Barbara, I can speak to that one directly. Those folks, we had by policy at PDS, we went through our Kaizen process a couple of years ago, redefined the building permit process to include critical area assessment.
Right.
So if those folks who had applied for critical area assessment up front were considered vested to their building permit application.
Okay.
So those folks, for example, we've already notified those folks that they have, their permits are vested to pre-Hearst.
So they can go ahead and finish the process.
Correct.
And that's about 80.
I think it was in the neighborhood of 40 or 50 or the folks that
Well,
were in
you
that
said
category.
subdivision, to me, it's their subdivision, and then
No,
there's
those are
individual
building permit
lots.
applicants. They're vested to the building permit application process.
To the okay, to the process, that's good.
And again, the issue here is building permit vesting through the building code, right? That addresses building permit applications, whether they are in a subdivision or not.
Okay.
Separately, the subdivision also through the statute offers vesting. The issue here, I think, is that while it vests subdivision applications, it doesn't insulate subsequent building permit applications from the need to review those building permit applications under 1927-097. Meaning you don't get,
The
because
exempt well one?
a subdivision that was filed prior to Hearst, yes, a building permit application that comes in later still has to be reviewed pursuant to 1927-097. So it's not, and that as is interpreted by the court. So it's a little bit of a different, as Mark said, that's why the kind of permit that we're talking about is really important to think through, because it impacts the analysis and the county's approach.
Barbara, I'm sorry to interrupt again. I know I'm not supposed to do this, but the thing you guys have mentioned, the first step of the building.
Please take your seat, Zach.
I will talk to you. We'll
I know,
talk.
but you guys are missing me by this month.
Zach,
You wouldn't
stop
admit
it.
I
Stop
started
it,
the
Zach.
process.
Stop it. You're hurting your case, trust me.
Anybody who's already started I'm talking simple, and you're going into numbers, code numbers, this and that, and I can't follow that, I want anybody who has started the process, who's been in there, who's done any of the work at all, or not, but started working on the applications, who's spent money. That's what I'm talking about. And I know I'm making it really simple, and it's not up to me to get into the minutia of how that works.
Mr. Chair, I'm just going to ask if people are going to have conversations, they should do them outside the room.
But you guys are missing the point. They're keeping
Zach, I have to agree with Mr. Mann. You are not helping your position by No, you're not helping your position. The next response from the council typically is to get up and leave until this changes, because we cannot have interruptions. No, you've had your, sorry, I didn't want to usurp your position, Mr. Chair. It's frustrating.
Look, can I ask a question of staff? Mr. Chair, can I ask a question of staff? I think what Ms. Brenner is getting at, and which I agree with, is there's steps in the process that happen prior to submitting a complete building permit package, whether it's a permit to drill your test well, or boundary line adjustment, or as someone said, critical areas ordinance, wetlands delineation, clearing and grading permit. Zach, stop it. I'm serious. It's not funny. Stop it. So how do we measure that? What is that called in the process or not? And I'm
That's
looking
what
at you guys.
Who have begun the process, like just what he said.
So our interpretations to date have been that if as Todd has talked about, there's vesting statutes that relate to building permits and those that relate to subdivisions. We've interpreted those in our application of the Hearst rule already in determining and helping folks decide if we can, because of the decision, if we can issue a permit based on a permit exempt well. We are happy to talk to council in more detail about the intricacies of that, but it is getting into complex legal issues that we can't talk about necessarily in public or codify in one fell swoop. There are many issues involved now that growth management law and water law are now intertwined. And so there isn't a simple answer, I'm sorry, Councilmember Brenner, to a lot of these questions and to what you would like. We understand what you'd like to do, and we'd be happy to work with council in the coming weeks and months on refining that process and seeing what we can do about that. But at the moment, that's why it's not codified, is because there's just, it's a very complex legal process to go through.
But it used to be that once you even submitted something, you were vested. That's changed. Now you got to do all these studies and all these other things, and then, then you can get your application vested. What I'm saying is, anybody who's begun the process, who's spent money on studies, on anything, and that may not work well for you guys, so I just believe that that's where we need to draw the line, period.
I don't know that it's not necessarily something that doesn't work for us, Barbara. There have been other Supreme Court cases on vesting of permits and subdivisions that have come down in the last several years that lay the legal groundwork for this, and we're simply trying to comply with that in our interpretations now that Hearst is also upon us. So that's all I'm saying. There's a great deal of complexity to it, and it isn't a simple, just X, Y, and Z, and you're good to go necessarily.
Okay.
So we're happy to work with council on talking with you about what we can refine in terms of codifying. I remind you, this is an interim ordinance. It can be amended at any time.
I want it to be an emergency ordinance and be done tonight. And just because I am so shocked that there are so few people we're talking about. I thought it was in the thousands.
No.
And it's so unfair because we're talking about a much smaller amount of people. And did you find it? Okay. Okay, you read it.
Okay, well, this is Councilmember Brenner's proposal.
Yeah, but you read it.
No, this is in terms of trying to define in the process. This was, I haven't looked at this for a while. They're active prior to October 26, and some combination of the following: designed, approved a septic system prior to October 26, installed a well prior to October 26, established the well's water's potable, established state-approved water system, completed a wetland study, delineated wetlands and buffers, natural resource assessment, hired an archaeological consultant. Just as a stab trying to figure out some definition of in the process, or records of meeting with county staff over the past X amount of time.
And I want to say he did want it introduced and was talked out of it, but I wanted to support it, but it wasn't my motion.
But I also said these permits are conditional. The applicant may be required to mitigate water use so as not to impair rights that are senior. And that's not defining what that mitigation would be.
No, but it's there, yeah, and the waiver. And that would be, for now, that would be
But I'm
it.
just saying, if you're looking for a place to start.
Yes, yeah. Okay, that's what I want to see on it. what he brought forward about a month or two ago and pulled it out.
And
those are the things.
Can I comment on this? And I'm not, we have been waiting, I don't think 6 months is appropriate actually, but if we keep extending this, I don't think we have we reduce our incentive to deal with this stuff, and we're just kind of waiting for a legislative fix. And I don't think it'll necessarily fix these things. It's not going to necessarily create more water, so we still need to mitigate. But okay, then the worry about this, why it was pulled, was that, well, then this could potentially increase the risk of this going to the hearings board and us being either not compliant or invalid, and that gets to the circular loophole. Then we wouldn't be able to do anything. And I'm not sure how worried I am about that, being that I don't feel that we're making progress on compliance agreement, on planning for mitigation, on dealing with these sorts of situations. So if I thought that we were in kind of some active process moving towards compliance and dealing with this, I wouldn't have thrown it out. But I don't feel that any necessarily that much more now than I did 3 months ago. I know that and I really appreciate what staff's trying to do. I know we're trying to do these things.
Yeah, and
but not in a way we
I'm
can
not
really
blaming
clearly
staff.
explain.
I'm not blaming staff, and it's like maybe there's some time for us. I don't care if I take the heat or we take the heat or anything. This is explaining, and I love what you put in here. This is explaining that somebody has actually done some of the studies, some of the processes that they need to get a building permit. And I thought it was very well done initially.
This is a draft. I'm not sure this is the one we actually.
Well, I liked it. I saw this last month or whenever it was.
I think it provides some pretty clear thresholds for having done something or been in the process.
Yeah.
And I know Tadas is going to say it doesn't fly with the Supreme Court decision, but I think, I think that's no, I heard it, it's okay. But I think, we can, between that and the disclaimer, I'm comfortable letting people take on their own risk instead of us telling them that they can't do it, it's too risky.
Mr. Weimer.
Well, I'm going to speak against the amendment. It's not well hatched. I don't know where it goes in here. I don't know what the wording is we're even discussing. I don't think we're going to spend the next 3 hours trying to figure it out. Well, that wording that you read isn't going to get me there. And I'd like to remind people, it's kind of weird to have to try to talk about this, but we've talked about these numbers, so I'm not sure why you're so surprised. We've talked about the effects of doing this that we're talking about. Maybe we need to do like Mr. Brown says and go into executive session and hear it all again, but we've heard it multiple times.
Mr. Brown.
Well, a couple of things just from a legal perspective. I think to make a substantive change to the ordinance at this point is not something we are even allowed to do on the fly.
On an emergency ordinance, you can.
Not an emergency ordinance at this point.
It is what I said, it's an emergency.
It's not.
It's not. This is an interim ordinance.
At this point, it's an interim ordinance.
So
That is, but I'm doing an emergency ordinance,
Where is it?
right here.
Let me offer up an idea, kind of taking into account what Mr. Brown has said. We have to have a extra meeting next week anyway, because of items that we didn't get through today. This interim ordinance that we are currently sitting on expires on the 18th of March. I think if Mr. Brown's idea, if the council is interested in doing an executive session to deal with some of the ideas Ms. Brenner's talking about, some of the ideas Mr. Donovan is talking about, and Mr. Brown has some questions he has with the ordinance as well, we could do this on next Tuesday and still, go ahead.
If you were to wait until next week, this interim ordinance will not be effective prior to the date that the current ordinance expires.
Because of the 10 days.
Correct.
So then really our only other option is to adjourn to executive session at this point.
We have one other option, Mr. Chairman. The other option is to pass this as it is now, because we have the option to amend it at any time. So we can pass this so it gives us the time to do this job properly. That's true. And then, but there's nothing to stop us from the moment we've passed it to be working on amending it.
I have a suggestion.
Ms. Brenner?
Except that we keep postponing and we keep postponing. And it's really, we've gotten to the point where it's not fair to people who've already invested into getting their information and their studies together for their permit. And I think we could at least do that. If the hearings board would invalidate us or do something over something like a few hundred permits of people who were already in the system when the decision was made,
Mr. Chair.
I don't know. There's something so ridiculous about even making that assumption. And that's the problem is this council, no offense, Tadas, but through our legal representation, everybody's scared of their own shadow. They don't want to do anything. And it's always, trying to blame somebody else. Well, we're it now. And we can't keep blaming others. I think we should do it. And I'm proposing Todd's former proposal as an emergency ordinance.
Mr. Sadoo?
I think we have to keep it on the front burner. We cannot just pass it on for the next 3 months or something. If there is a legal issue that we have to do something today, we can extend it by 4 weeks. That's it. Because we do not want to put it for 3 months and then forget about it. But let's do it for 4 weeks, but stay on it. Let's have a meeting next Tuesday. Let's have the executive session. Like I said, we may be wrong. I'd rather be wrong, but take a decision. We cannot be that afraid that we don't want to take a decision and keep postponing. I'm all okay for having a meeting next week. And if we extend it for a month, we still have ability to change it again, but we are not then up against some legal conundrum.
Mr. Brown?
I just don't want it to be lost that the risk is not just to the county and the Supreme Court. The risk, as I understand it, is if we say, hey, go ahead and build, and then the Supreme Court or the hearings board or whatever says we're now giving you a declaration of invalidity, my understanding is you can be told to stop. And I guess if I was a landowner who is looking at building a property, I'd rather be told not to build now, or that I can't build now, than be told I can build and then halfway through construction, I'm going to be told I have to stop. So that's what I'm concerned about, and I want to make sure that anything we do doesn't put homeowners or landowners in that position. I think it's a far worse position than what they're in today.
Yes, Ms. Brennan.
Ken.
Oh, Mr. Command.
So this is where Mr. Brown and I disagree frequently, but I think that is an individual citizen's right to make lousy decisions. And we can't.
But this isn't necessarily a lousy decision.
But no, that's the fundamental thing we disagree on generally. I do not want to be in the position of telling people they're not allowed to take that risk. That is their own risk and their own decision, and we should let them evaluate their options and their opportunities and their risks. We'll fully inform them, give them that waiver or their disclaimer, and really, they can make up their own mind.
Mr. Donovan?
I like the idea of just maybe limiting this to a month, but I initially threw out this kind of language to get a discussion going, and then it sort of died, but I really had hoped that had been with the litigants and the county in terms of like, where could we reach some kind of agreement on that? And we're supposed to have a compliance agreement by May 19th. So, and the legislature's not going to have anything figured out till into June probably. But I agree that this is not the time to try to be putting that kind of language into this ordinance. But I want us to be having that discussion, not just in executive session. And I kind of lost track of what the motion is right now. But there's other things, the language about the well drilling, the fees for the hydrologist stuff. Those are other things that need to be fixed, in addition to hopefully codifying something about what we can do with people who are in the process.
Ms. Brenner?
Okay, this is the emergency amendment. Amend AB 2016-309A 24.11.060 A5 as a new OR. So these are all ORs. If you've done any of these, and if anybody wants a copy, that's fine. I've gotten stuff that was emergency that I didn't even see till we got on the floor. So to tell me we can't do this is ridiculous. This is small 1, either that, or small 2, or small 3, or small 4, or small 5. So if they've done any of these things, because it's OR, then they are vested and can move ahead and get finished with their building permit.
Small 5 says a permit issued under this section does not grant the applicant water rights.
I didn't say it did, and it grants them the ability to finish their proposal, including drilling a well. And, yeah, I can't even imagine they're that heartless at the hearings board, that people who've already gotten in the door and have been working on stuff would be stopped from finishing. I just don't buy it. Especially when we're only talking about a few hundred people. Initially, we were saying it was thousands, and now I am shocked that it's only a few hundred people.
Okay, my first question is for legal, and that
No offense, but.
Can we turn something like this, can this even be considered as an emergency ordinance? Liz?
Yeah, we've been discussing that, and I was looking up the county code. At this point, we don't think it qualifies as emergency.
We're operating right now under 3678-390, which allows adoption of interim controls and allows for successive renewal of successive up to 6-month periods, provided the public hearing's held. So there's an issue here about we're sort of past the first one and now we're at the second one that I think we're just trying to track with the county code to make sure that we're syncing with that. But that would be the concern, is that we're now renewing already a previously adopted interim ordinance, so the procedure's a little unorthodox.
But it's already been amended.
But this is
Correct.
amending it as an emergency ordinance. This happened not that long ago on something, and I hadn't seen it till it got on the floor. So, and I had to vote on it.
The amendments that we're talking about in the second were part of the packet that's gone out. So that's the only difference between the amendment we're talking about now and this one. So it's just the discussion that would benefit from procedurally making sure that we're in sync with the county code provisions on this topic. But also, I think there's procedurally the other discussion of the other option available to the council is to adopt the interim controls that are proposed for a short time period and then work on the amendments at a subsequent meeting. That's the other alternative.
No, or to adopt this as an emergency ordinance.
Do you guys have a copy of this down there?
I just got it.
Okay.
Yeah.
Yes.
I will speak against Council Member Brenner's proposal about this stuff I wrote. No, because I didn't propose this as this is exactly 1 through 8. This doesn't say what combination of these things it would be or how many it would be, but it's just to try to start defining what it means to be in the process in terms of these people we're trying to make whole. But it also is somewhat dependent on those numbers. Are we talking 220? When you mentioned the natural resource assessment, that covered 40. So we now know that. I don't think we had those numbers when this first came out. So one thing we need to do is figure out some ballpark number before I think we can, and how many of these conditions would have to be. So I don't think we can just throw this out into the ordinance tonight, but I want it to be a starting point for defining who's in the process that might be able to get a conditional permit that would require mitigation and does not grant water rights.
Ms. Brenner.
Mr. Personius said it's a few hundred that are somewhere along the process. To me, that is definitely worth.
Tyler Schroeder, Deputy Executive. One point to the emergency ordinance. My understanding is council would have to declare what an emergency is and prepare an ordinance similar to the ordinance we did when council adopted the moratorium.
Okay.
So in this, there is no whereases, there's no therefores, there is no indication of what the emergency is.
It's not to form.
My understanding is that Mark Personius was trying to articulate the number of applicants that had applied for permits prior to the Hearst decision, that had natural resource assessments prior to the Hearst decisions, and those are the process and the permits that we've moved through the process as articulated earlier. It's very hard for the county staff to give council an indication of the number of applicants that's delineated wetlands or buffers prior to October 26, 2016. It's very hard for the county to establish, the applicant has established a well water that is potable prior to October 26, 2016. So there's a lot of requirements that this language
But I said
is
there
on
or.
applicants that the county doesn't really have the information to provide to the council how many people this is inclusive. We've had conversations about this ordinance. If the council's interested in moving forward, I would make a recommendation. The ordinance as written today gets passed, and we continue to have conversations as appropriate and think about where actually this ordinance should go and what should be in the ordinance before council takes the action of adopting an interim ordinance.
Yes, Ms. Brenner.
That's what we've been asking for months now. And he said it's a few hundred people from wherever they are in the process. And I respectfully disagree. I know that, some people like this process that keeps going on and on and on, but it's not fair. And the emergency could be that some people are homeless because they can't get their house built. That's quite an emergency. And I'm willing to say that's the emergency.
Mr. Sadoo.
I think that we are on the right track, but the biggest thing is that we must define certain bullet points that if you have done this, you are passed. If you've done this, you're passed. Or we should have a list of 7 items or 5 items. If you've done any 3 of those, out of those 7, you are vested. So that, like the fear is, if it is 500 people, and if we put this thing out, and there may be 700 people who qualify. So what? I mean, what is the thing that we have to limit to only? That's what I see, that is the fear, that if we put it out there will be a lot more people qualify. People cannot go back and change their history. It's there. Did they apply for that, or did they make an application? There's a date, there's a stamp. All those things are established. Nobody can come back and change that. Oh, if I do this, then I can get qualified. I think that if we really seriously look at it, and you guys are more experts, and we depend on that, your expertise. We are not land use experts. But we want to know that, okay, these are the 5 or 7 things normally people have to do to get a permit or get qualified or go build a home. And then we should say, okay, if you have done any 4 of these, go ahead. It doesn't matter which order, because there is a complications. We do not have a process where there is a step 1 and 2 and 3 and 4. It jumps all over, goes sideways when you are doing this kind of work. That much I know. It's not a linear process. There are several things happening at the same time. So why don't we just come up with something and do that? And if there are 300 more, I'd rather give benefit of doubt to the applicants than to the county. If there are few hundred more people qualify, let it be.
Ms. Brenner.
And all it has to say would be evidence that a single-family home project was activated prior to October 26th. activated means that you've started doing something. You've started getting different assessments done, or the well done, or anything, but it's active. It's not approved, but it's active. That's it.
Mr. Brown?
A couple of points, just to, while I generally agree with my colleague, Mr. Mann, the one area where we disagree on is not actually on the right for a citizen to make a bad decision, it's just on the right for a citizen to make a decision that affects the safety of someone else in the future. So on that point, I just want to stress, I am incredibly sympathetic to everybody who's affected by this. I've personally spent hundreds of hours on this. I've been to Olympia 3 times. I've looked at all the bills. I've worked on mitigation plans. I don't want anybody in here thinking that I'm indifferent to the situation or that I don't want a solution, because I do. The thing is, we've got to do it right, and I would like to see us pass this ordinance now and immediately go back into executive session Tuesday and thresh out every possible opportunity that we've got to give relief now, particularly as one of the things that we do have that we can look at is we can, while we don't have decisions out of the legislature yet, we have a sense of what is going to move forward, and at least get some idea that whatever we come up with is at least going to be consistent with the changes in the state legislation. So that's my ask, is vote for this one now. If we need to put a 4-week window on it, put a 4-week window on it, but let's vote for this one now and continue the efforts to try and find ways to give people immediate relief, short-term relief for those who are most immediately affected, and then long-term relief for the rest of the citizens.
And it looks like the timing is a 6-week window, is what I've been told.
6 weeks, okay.
Okay.
By staff.
Okay, so 6 weeks.
6 weeks from the effective date of the ordinance if you pass it tonight.
It'd have to be at least 6 weeks.
But we can change it any time.
To get 4 more
You
weeks.
can change it any time.
Yeah, that's fine.
So I amend my comment to 6 weeks from 4 weeks.
Ms. Brenner?
Well, all this time you've spent on it and your trips to, I wanted to go down there, but nobody would give me a ride. So I called the Wasatch person and gave her all my proposals and listened to it and spent at least that many hours on it. That's our job.
No, I don't know.
Well, it's not like, I mean, we're supposed to do that. People are not supposed to be screwed by the government. And that's just what has happened. And it seems to me that I can't imagine that we can't allow people who have already started the process not to be vested. And I'm sticking with this. My amendment, my motion is for an emergency ordinance and using the numbered stuff that Todd gave, or Councilmember Donovan gave me, that it would be any of those ors.
Mr. Brown?
First of all, I don't want my comments to be taken in any way that I'm suggesting that other members of the council or staff haven't put considerable hours into solving this problem, yourself included. I respect the amount of time you spent on this. I just don't want people going away thinking that this is just a casual thing for us and we're not working our behinds off trying to solve the problem.
Mr. Sadhu.
I want to say the same thing. It's not that we're beating our drum. I haven't worked harder to defend my thesis than the time I've put in since October into this, the notes and talking to people, talking not only the affected people, which are totally emotional. They think that you are sitting on that seat, you can make it. That's all they say. You can do it. It's not that simple. But it's not for lack of our work or our consultations or our will. I just want to record that for everybody, that we're not just sitting, come here on Tuesday, say, oh, it can't be done.
Ms. Brenner?
Well, again, I'm just going to say, that is our job. It's not people's job to be held up after they've already begun a process. And it's not fair, and we should do this, and we should do it as an emergency ordinance tonight. And then, you know what? You want to make some amendments? Make amendments over the next several weeks. But this is what I want to see for tonight, is that we do this.
Ms. Brenner, sorry. Ms. Brenner, I completely agree with you. This is not fair. This is absolutely not fair. But we're a political subdivision of the state of Washington, and we're subject to the laws of the Supreme Court and the Growth Management Hearings Board, and that's the environment we live in. Sorry, Mr. Chair.
Well, did you have anything?
I was just going to add, I think, in terms of the one, and I don't hope this isn't a gratuitous comment, but in terms of the fighting for this, I think it's just worth reflecting that the county did for 4 years. And even going back to the very beginning where we started with Mr. Carmichael's 2 points, the county argued those things before the Supreme Court, and the Supreme Court rejected those arguments. So we're in part somewhere here. I want the legal battle sort of extends prior to the adoption of this ordinance, and that's part of and now we're on the next phase, and we're working towards that.
Ms. Brenner?
I don't remember the Supreme Court saying anything about people whose permits were already in the process. They didn't get them yet, but they were talking in a very broad, base about this is, and I have to disagree with whoever said, they're not making law. They did make law, actually. They changed decades of law. So I'm just saying that I'm only talking about the people who'd already done it. The rest of them, I want to help them too, but we have to start somewhere. And those people who've already spent money and have tried to get stuff done should not be held up anymore.
Just to clarify, you're absolutely correct. The court, there's sort of what we know and what we don't know, and the court ruled on the compliance of the county's regulations and its rural element with the GMA, and this is sort of the ripple effect of what does that mean, and those are the complicated details that we're wrestling with. So you're absolutely right. I was more referring to this issue about sort of the defense of the county's approach more generally as just worth reflection and
I get it. I'm just saying anyone who started the process before the date should be allowed to finish. And it doesn't sound like it's very many.
Liz, did you guys make any determination on the vehicle of a emergency ordinance?
So at the very least, under the GMA provision, there would need to be specific findings adopted pursuant and to the terms. So that's something that's not there yet. And then
Okay, my finding is that people are being unduly burdened who have already been in the process. We don't need a whole bunch of findings.
in terms of the declaration of emergency.
Well, that's the reason for the declaration of emergency.
I'm just looking at Whatcom County Code 2.02135, the authority of county council to make an emergency ordinance. And I'm just citing an emergency ordinance necessary for the immediate preservation of the public peace, health, or safety, or support of the county government and its institutions.
Okay.
So it would be my opinion that what's been articulated by the county council, Ms. Brenner, does not fit that standard at this time, but I'm just.
So you don't think people made homeless because they can't get their house built and move into it is not
tonight.
affecting public health or safety?
Not tonight or within the time frame that the county council can maybe have time to amend it. But that's, I don't know.
I guess you've never been homeless. Well, I have.
And it would have to be by a vote of 2/3 of the council.
That's true, yeah.
Yeah.
Mr. Weimer?
Well, I don't think we have an adequate ordinance in front of us, so
Yeah.
I'm not going to vote in favor of it, but I think we beat this horse to death, so I'd like to call the question.
Do we have a second to that? Second.
Which was an amendment to the what is?
We have, no, this
No,
is just to call the question.
calling
Okay.
the
Call the question on the issue of the emergency.
On the amendment.
There's
Okay.
no
The
more.
emergency.
It's been moved and seconded. Any discussion? In fact, there's no discussion on call for the question.
I guess we need to know what question we're
That's
voting on.
what
I
I'm
thought we
trying
were
to figure
voting
out.
on the proposed emergency ordinance.
Yeah, I can't answer that. I don't.
I think we have to still amend it in terms of at least the time length on it? Or are you calling it as a 6-month? Are
I
we
think
voting on
that
it?
the motion on the floor is
The
Barbara's
motion on the floor at this point
emergency.
in time is to call the question. That's all.
And the question is,
The question is to
Okay.
vote on this thing, then we can, so all those in favor of calling the question, say aye. Aye. Opposed?
No, not ready to call for.
Okay, so that passes 6-1 with Ms. Brenner opposed. So now the question before us is, you want to call, I'm going to let you explain it because I don't want to paraphrase you incorrectly.
Okay, what do you want me to do? I made the motion already.
Restate it.
The motion is to amend AB 216-309A 24.11.060 A5 as a new or. And so it would be or after each paragraph. And these are all about what people can do to have been considered in the process before the decision came down, the Supreme Court decision.
Okay, so the way you stated that is that it would be an amendment to the existing ordinance.
Well, an emergency.
Are you still, you need to clarify, are you trying to introduce this as a new emergency ordinance? Or are you introducing this, as you read, amend, which is what we're looking at?
It's both. It's absolutely both. It's an amendment that's an emergency ordinance.
That doesn't jive.
Well, a lot of amendments are a lot of emergency ordinance are amendments.
Ms. Brenner, you know I love you. There's no such thing as an emergency amendment.
Okay, never
listen,
mind.
I am going to vote for this language if you get it in front of us in some kind of procedurally, legally supportable fashion, but you're gonna have to do that.
Okay, an emergency ordinance to amend?
No.
just pass the ordinance and then amend it?
No, I'm not passing the ordinance that's in our packet. I want this.
So you have to pick one of the two. You can choose this as an amendment.
Okay, how about, never mind.
Or you can choose.
Let's vote on this as an amendment, and then if it fails, at least you'll know your emergency ordinance has no shot as well. Let's see if there's even any support for incorporating this language into our code at this time.
But we'd have to do it as an emergency,
Right,
or we
but
can't
let's-
do it.
What I'm suggesting is that we vote on this as an amendment to the existing ordinance. If it fails, you can be sure it would fail later on as an emergency standalone ordinance.
That needs 5 votes.
Okay, never mind, I'm gonna state it out. This is an emergency ordinance that states that anybody who has a single-family residential project activated prior to October 26, 2016 will be allowed to continue and finish the project. And it would include evidence that a project was, we already said that. The applicant paid fees to Whatcom County directly related to advancing the project, including land disturbance permit fees, project permit fees, etc., prior to October 26, 2016. Or the applicant invested funds on consultant services related to the proposal, or the applicant has records of meetings with Whatcom County PDS staff related to the proposal within 2 years prior to October 26, 2016. That's my emergency ordinance.
That's your emergency, okay. So this is a supermajority vote.
Yeah.
Any further discussion on the?
Point of order.
Yes.
I mean, I hate to be the bearer of bad news, but this makes no sense to me.
Yes.
To just initiate an emergency ordinance in the midst of a calling the question decision.
I didn't call for the question.
I know you didn't, and we've got another motion on the floor and a properly introduced ordinance. I mean, I'm sure our clerk is probably going bonkers over here. I have no idea what you're doing. I guess I'll
They
just-
don't, but let's vote on it.
Okay.
Yeah, that's all you can do.
That's all we can do. We can let, she's made it, she has the right to make a motion. She's with an emergency ordinance. Let's vote on it. Mr. Weimer's called the question. I've seconded it. Let's vote on it.
So this is an emergency ordinance?
This is what Ms. Brenner has chosen to do.
Okay.
Okay, all those in favor of this emergency ordinance, say aye.
Aye.
Opposed?
No.
So that fails 1-6.
So, Mr. Chair, I think I think the next motion was my motion to put forward the existing ordinance for 6 weeks. And us to, I think you had suggested we reconvene next Tuesday, possibly have an executive session and see if we can amend that ordinance earlier.
Yeah.
Right.
Okay, do we have a second to that motion?
I second that.
Okay, Mr. Weimer?
I just had a question, because I thought we already had the motion on the floor with a second before any of this nonsense started.
Yeah.
So whatever happened to that motion?
We did, actually. You're correct. We had
You wouldn't feel that way if it was your.
the original motion on the floor was to pass this ordinance as is.
Right, and that was seconded.
And that was seconded.
And we
then
haven't
we
dealt
had
with that yet.
amendments. So is your motion just an amendment to amend the
Just the
time?
period, yeah, to bring it down to 6 weeks.
Yes.
Okay, does that make sense?
So it's an amendment we're voting on?
Yes.
Or, I mean, yeah, okay, either way. I mean,
Yeah, it would have to be an amendment.
I have a question for the clerk, that if we do it for 6 weeks, because that starts from March 18.
It would be, sorry, it would be 6 weeks from the effective date of this ordinance. So we still deliver this to the executive's office.
Okay.
He has a certain number of days to sign it.
Yeah, so say provide 2 more weeks from there, right? What I'm saying is, my question is that if we have a meeting next Tuesday and we come up with some kind of conclusion, and can we still amend that, or we have to wait for a certain period of time?
No, we could introduce it on the 21st and have a hearing 2 weeks later.
And we do have to have another hearing.
Yes.
Okay, that's, so I just want everybody to be clear that it will be another 2 weeks from that, and then it will go to the executive whenever he signs, and then it becomes effective.
Correct.
Mr. Brown?
You know, Mr. Chair, I mean, if we're going to work if we're going to put this into executive session and work on it further next Tuesday, and be aggressive at trying to find areas for relief, I can withdraw my motion to put the 6 weeks on and just vote on this as it's in the packet now, because we can amend it at any time going forward. I don't know what the will of the council is, but I'm easy either way.
I'm the same way. So, Mr. Sadoo?
I don't want it more than 6 weeks.
Okay.
Because we cannot put it on back burner, because you don't know what will come next week, something else will come up, and we'll say, okay, well, we got 6 months to go. No, let's keep it minimum 6 weeks, let's keep it 6 weeks, get on it and do whatever.
Ms. Brenner?
Take a decision.
I move to amend.
We already have a motion on the floor.
I know, and I move to amend it.
Okay?
I move to amend AB 2016-309A, 24.11.060, A5 as a new "or" quotes. A record that the project was.
Excuse me, Ms. Brenner, we have a motion on the floor for the 6 weeks. We have to handle that motion first.
Oh, before we do the content of what it is.
The motion on the floor right now is to amend to make it 6 weeks. That's the only thing that's on the
Okay,
floor.
it's
at
not
this
the
point.
thing itself.
It
All right,
supersedes.
okay.
Okay, any more discussion on the 6 weeks? Mr. Weimer?
I'm going to speak against the motion. We can amend this whenever we want. I don't think it holds our feet to the fire. It will force us to come back and deal with this again if we're not ready in 6 weeks. So it seems like we're better off just passing it as it is in the packet this evening.
Any other comments? Okay, all those in favor of the 6 week amendment signify with aye.
Aye.
Opposed?
No.
So that was Mr. Weimer, no, and who was the other one?
That was it.
Oh,
He just talked, he echoed.
he echoed. Okay, so that passes 6-1. Ms. Brenner?
You voting twice again?
Okay, I move to amend, do I have to say the whole thing over again?
No, I think we've heard it enough.
All right, I move to amend this new section that I stated.
We would actually like you to restate for the
Oh,
record.
okay.
Thank you.
Amend AB 2016-309A 24.11.060 A5 as a new or. A record that the single-family residential project was active prior to October 26, 2016, including evidence that a project was, or including the applicant paid fees to Whatcom County directly related to advancing the project, including land disturbance permit fees, project permits, et cetera, prior to October 26, 2016, or the applicant invested funds on consultant services related to the proposal, or the applicant has records of meetings with Whatcom County PDS staff related to the project within 2 years prior to October 26, 2016.
Second.
Thank you.
Okay, discussion. Mr. Donovan?
I will speak against this, and again, and I will say that I want to work with you and with staff, and I would hope we even maybe loop in the litigants to figure out what that list would look like. Maybe we get some information about how many units we're talking about, but or what a list would look like that would define the type of projects that would be covered by this. So I will not support this now, but I hope we can.
Mr. Sadoo?
I think this paper was prepared. It's just like back of an envelope thing. He was writing notes and wanted to discuss. I mean, there are unintended consequences of things we put in without any discussion. Like this suddenly came out of blue that let's print that and let's make that an emergency or amendment. I'm in favor of giving this relief and waiver 100%, but I cannot just do it hodgepodge. I mean, I don't think we have really discussed it enough. So is it proper, or does if person has done only one thing? I mean, we need to check with staff what the implications are. We can set ourselves up for lawsuits. Because it suits certain people, it doesn't suit the other people. They're going to say, well, why did you do it for them? I mean, 1 week.
Ms. Brenner?
I don't think it's hodgepodge at all. We just found out tonight how many applicants or how many potential permits this affects. And we didn't know this before tonight. So if you think it's hodgepodge, maybe it's because we haven't gotten the information we needed until now, but that is not my fault, and I'm moving on it because now we have it.
Mr. Sadoo?
My point is that it may very well end up with the same wording on there. I'm not saying hodgepodge in the sense, I'm saying our process is hodgepodge. I'm not saying this document is. But we have not really considered the document. What is the harm in making sure that we don't just, okay, sorry.
Okay, any other discussion on the amendment? See none, all those in favor say aye.
Aye.
Opposed?
No.
No. Who were the yeses? You were a yes?
No.
Oh, you were a no, okay.
On
So
this, right, in
Brenner
snow.
and Mann were in favor. So now we're back to the original amended ordinance at 6 weeks duration. Any further discussion on that? Ms. Brenner?
What happens if we don't pass this? Does that undo everything? And leaves it so people can proceed with a permit application?
It would, It would, at the expiration date of the existing ordinance, which is not tonight, but within the 18th.
18th.
Okay.
Okay, any further discussion? Seeing none, would the clerk please call the roll?
Barbara Brenner,
No.
Red Brown,
Yes.
Barry Buchanan.
Yes.
Todd Donovan,
Yes.
Ken Mann.
No.
Satpal Sidhu,
Yes.
Carl Weimer.
No.
So that passes 4-3 with Brenner, Mann, and Weimer opposed. We've been going for 4 hours now, so I think we need to take about a 10-minute bathroom break.
You're going to
So-
be in there for 10 minutes?
So we'll be back approximately 10:05. Call the meeting back to order.
Oh, gosh.
We're now on item number 2.
Item number 2.
It's a public hearing on ordinance establishing charges and fees for providing advanced life support, or ALS, ambulance transport services in Whatcom County. I don't see anybody out here that's probably have a staff report, so what's the wishes of the council? Or let's open the public hearing. I have nobody signed up. But does anybody want to talk to us about transport fees for advanced life support in the EMS system?
I move we hold until we can get somebody to tell us more specifics, maybe unless Tyler can do it tonight. Oh, she's coming up to see?
Okay, Karen Brand, resident of Whatcom County. I just buried my father-in-law of 95 years last fall, and I just got another frickin' ambulance bill, $989. I'm telling you, that's a little excessive, somewhere along the line.
Can I ask a question?
Yeah.
This was in addition to a bill you got already? From?
No, this is another one that just appeared from, I don't know, I'm not home to call today to inquire because I had not gotten a bill from out-of-state ambulance services for somebody that says they're billing for Whatcom County ambulance services. It's different than any I had in the past. $900 is a lot of bucks.
Well, and this
for
was
old
to
people, excuse me.
take him, this was to pick him up and take him to the hospital?
It was taken from the chateau in Fairhaven to the hospital. That's all I can tell you.
I was just wondering what else.
No, that's all.
Okay.
And so, you know, you had a bed downstairs.
Wait, that's
excessive, I'm sorry. I don't know what kind of numbers you have, but $900 per trip to the hospital is excessive, I think.
And, never mind. I was just, something doesn't sound.
Okay, thank you, Karen. Anyone else want to speak to us about EMS, ALS prices? If not, I will close the public hearing. What are the wishes of the council?
Move approval.
Second?
We have a motion and a second. Discussion. Those rates are on page 384 of your
Right, I
packet.
saw them, but didn't, 380, let me get there, hold on. 384. But they, 84.
So discussion? Ms. Brenner?
Well, I just would like to know, there's ALS 1 and there's ALS 2, and I don't really know what, you know.
There's a description there.
I know, but that's what most of it sounds like, and then 2 sounded like that they were gonna give them all kinds of medications and do stuff on them and things like that. Or not necessarily him, her, the person. So, yeah, defibrillation and, so I don't understand if somebody's just getting a trip to the hospital. We don't know.
It's advanced life support transport is not like taking an Uber. It's you got paramedics coming, you got the full-on ambulance, they can give you all kind of drugs and interventions.
No, not for ALS 1.
Yes, it is.
It's not the full package, but it's more than just a transport. A transport is like basic life, that's BLS. This is ALS 1, ALS 2.
ALS, not BLS, what? I know what you're saying. I'm just saying ALS 1 is still in the 700 mark.
Right.
And now I don't know what happened.
I don't know what happened there either, but it's not just a ride to the hospital.
No, I know that. It's just,
Mr. Donovan?
I was just pointing out that this is a proposal for an inflation adjustment to the current fee of $16 for ALS 1 and $20 for ALS 2. I think I'm reading that right.
Yeah, it comes to 2% or less. I was just looking at it.
Mr. Brown?
Just as a note, the difference between ALS1 and ALS2 is whether they give at least 3 medications or other things. So they're doing, it's for the extra stuff that they're doing.
And defibrillation, all that, which they're not doing on ALS1.
No, but that's, so if you get transported in an ALS van and then they have to do defib and have to give you medications, then you're going to pay an extra fee. There was extra expenses incurred.
Yeah, I'm saying, but that didn't sound like what happened.
Any other discussion?
I'll check into that with you anyway. That's real. Yeah,
Okay.
I'm fine if that's, if.
Okay, seeing none, please call the roll.
Rudd Brown,
Yes.
Barry Buchanan.
Yes.
Todd Donovan,
Yes.
Ken Mann,
Yes.
Satpal Sidhu,
Yes.
Carl Weimer,
Yes.
Barbara Brenner.
Yes.
That passes unanimously. All right, our next public hearing is on a resolution to sell tax title property by public auction. Do we have anything at all, Steve?
Steve Oliver, Whatcom County Treasurer. This resolution embodies the unanimous recommendation of the Property Management Committee to sell the property at public auction for no less than the foreclosed taxes, penalty, interest, and costs. Now, a lot of the tax title property that we wind up bringing to you over the years. This one's a little different in that it actually is a legal lot. If there is any activity, or if there's any questions related to that, Mark's still here. He can answer those for us.
Okay.
Yes.
My only question was, I was trying to find this on Google Earth and failed. Is there any possibility that this might be useful for building the Kendall Trail as an access point for the Kendall Trail?
The Parks Department, participates in the Property Management Committee, and they didn't see any public value in maintaining that space.
Is this on the route of the Kendall Trail?
No, Zach.
Mike McFarland, County Parks. That particular lot, the route isn't well defined. In the last conversation we had with DOT, in there, the section of trail there, right in that particular area, would follow along the road right of way. There are also some private parcels in there that others have looked at, that individuals have said, we are not ever going to sell this, or they've taken and incorporated them into their existing properties. So the Park Department has not been actively involved on that. This is something that DOT and the community has been involved up in there. But that particular lot did not appear to be on the route that's being chosen right now.
Is there any urgency to sell it?
Yeah, we foreclosed on this parcel in 2012, and
What's another?
I don't know if there's any sense of urgency other than in this instance, the Property Management Committee felt that the highest and best use was to get it back on the tax rolls.
And I normally don't disagree with you, just that I'm a big fan of trying to get the Kendall Trail going, and if we happen to own a piece of property for $2,000, I'd personally like to just wait until at least the trail's defined before we, just in case, because it's not going to, $2,000 is not going to make any difference to us one way or the other.
Understood. Yeah. I would just mention for the record that Mr. Nutting is an adjacent property owner to this lot, and he promised he'd be on his best behavior if he had any comments.
Well, he's certainly willing to testify at the public hearing. As soon as we open it, we're almost there.
I had a question for Steve.
Mr. Mann?
Is one of the reasons we sell these, is owning it carry its own set of costs and liabilities, and whether there's dumping or things like that, is that a reason to get this out of our ownership?
Well, tax title property is, it's actually a little less than county ownership. Really, when property is considered tax title property, we're really acting as a trustee on behalf of all of the taxing districts. So, our interest in it is certainly a little less than fully owning the property. But I think we do have some trustee responsibilities, to the public. And, owning these properties, I think that, if there was, some issue related to it in the future, as the trustee, I think we would be, people would be expecting us to take some responsibility for it.
Because there's a number of these really thin tracks all throughout the area, and I get calls, about once a year, or, about once a year, but sometimes it'll be like 10 times in one day, when someone starts cutting trees down on these little strips, because people think it's their backyard and don't realize it. I guess there's some remnant of when it was platted and they left trails and then never did anything, and people think it's their backyard and it's not, and then other people own it, and then they cut trees, and it actually creates a lot of conflict out there. So part of me wants to keep it to avoid that again.
Yeah, and you'll see that actually, on the dogleg end of it there, adjoining lot 37, you can see that the end of that has already been deeded to the owner of lot 37. So it's kind of a landlocked parcel at this point.
It looks like there's access at both ends now, though. I mean, Chateau Road is there, right? And Dardu Road is there. It's a nice little trail.
My recommendation would be that the county needs to buy it if they want to preserve it for that purpose.
Ms. Brenner was next.
No, that's okay.
Okay, Mr. Brown?
Sorry, I just wanted to clarify. You've got there's a green shaded section and the yellow section. What are we talking about, the green or the yellow?
I don't have a colored.
Yellow is the really long one on ours, green is.
Okay, then I withdraw my objection. Okay, all right, I withdraw my consent.
Okay. So we will open the public hearing. Zach, you can come on down and.
Why is this one green?
So a little confusing. This is the first property I lived in. The one that we've sold is right next to this. Originally, it was owned by Bill Eisenhart and a partner through Crown Imperial Development or something. Mr. Eisenhart died. I contacted Shirley, his wife, and the original owner, and was given the property. I didn't do the paperwork quick enough, and it got seized through county tax title. You talked about liability. It's currently a dump site. I've had a tree expert out. There's at least 8 trees that are putting the current house that I'm stuck in danger. Was one of our motivations to sell it. They're over 150 feet tall, and because there's no trees on the adjoining lots, they're all leaning incredibly hard. So the tree expert said he would not sleep in my house. Again, one of the reasons we moved to sell it. I would like to buy it. As far as the trail, it doesn't work because the 2 inns that join Dardu and Chateau have been sold. There is one that does still join Chateau immediately behind my property, which was originally the reason we wanted to purchase it, to get our access off of the highway. So I hope that explains it a little. It would definitely be in better use in my hands than it is now, because I mean, it literally is a garbage dump. There's garbage littered in the trees. As you said, people do occasionally go back there and cut some of the trees, even though they don't own it. And so, if it was mine, it would be incorporated into my property and potentially be a building site later, because it does have water electric and all of those things.
Which is
available
your
for-
site?
I own 7848 and 7856 Kendall Roads, so that would be, if you've got the map, I could point it out to you.
Yeah.
Such an odd shaped lot.
I own these two right here already.
Okay.
But you can get access here. This one is gone, and as far as I know, that one would be the one of these
But
properties.
you can't get access off of Kendall Road, can you?
These two properties, that's what I drive.
Really?
That's my drive.
Oh, okay. So he's pointing to, on our map, you guys, on the XY coordinates, X310, right above the green,
Yeah.
310-205 and 310-199. Also known as lots 29 and 28, I think. The green one and the one right above the green one.
This is not the property number you gave me, though.
Now, this is the property, this is the half-acre lot with the two-bedroom mobile that I originally lived in that is supposed to belong to my mom now. This action, I paid the money to have this brought to your guys' attention, to be brought to public auction like 8 months ago. This is just how long it's taken to get to this point. Long before I began the process of buying a different property and building a house.
The property that you told me you were having problems getting water from is not this property.
No, is not this property.
So
This
you're
is the
planning on
property that I'm currently staying on with the home.
So you're planning on going to the auction and buying the yellow?
Yes.
Okay.
It turns my 2 quarter-acre lots, with the addition of that, I have an acre, so there's a little more room for my kids to play while we're stuck there. And again, if you guys looked at it, you would see these trees are huge, they're gonna come down on my house, and the garbage is just ridiculous. Someone needs to do something about it. You listed,
I can tell you right now, one of the neighbors is gonna be really upset when you start cutting trees.
oh, you know one?
Yeah.
I'm surprised, because most of them are dead, but.
Most of the trees are dead?
He's
No,
makes
the
it.
neighbors, in that neighborhood, Dardu and Chateau, 2 out of 4 homes are zombie homes. 2 of my 4 neighbors are dead people. The homes are in some state or another of no ownership. They're just sit empty and dilapidated.
Unless you don't have problems with your neighbours.
Yeah. Well, the ones that died were better than the homeless ones that have been in and out, but,
I would just note that, it's just, a matter of process. I mean, we notified all of the adjacent property owners of this hearing, and we'll let them know when the sale is.
Yeah, one of them called me today.
We've heard from a couple of them, just expressing interest in the sale.
Oh, I move approval.
We're still in public hearing,
Oh.
so
want me to
thanks.
get out here?
Thanks, Zach.
Yep.
Anybody else want to speak to us about this? Seeing no one, we'll close the public hearing, and
Now I'll move approval.
now we move approval. We have a motion and a second. Any discussion? Seeing none, this is a voice vote. All those in favor, say aye.
Aye.
Opposed? That passes unanimously. Okay. Now we're at open session. So during open session, members of the public will have up to 3 minutes to address the council on any issue relevant to county business, other than anything that's already been discussed tonight at the public hearings. Before beginning to comment, please state your name and topic of interest for the record. And if your last name is complicated, please spell it for us, and make sure to speak into the microphone. So we will open the open session.
Good evening, Chris Halterman, Whatcom County. I'd like to address your potential to introduce the changes to the Cherry Point growth plan in your comp plan. And one of the things that I have found disconcerting, especially after listening to everything today, a lot of the commonalities that I hear is potentials for lawsuit, the need for money to pay for infrastructure. And in reading some of the comments within the Whatcom County Planning Commission that you put this out to look at and revise and bring forward to you, I found it really disconcerting, some of the language that was used during the comments section in the minutes. And I'll just read a couple of these, and I just want to be on record my concern that doing this change to the Cherry Point growth plan is setting Whatcom County up for more litigation that you can't afford, or we can't afford. Commissioner McClendon asked Mr. Buckingham if the county has a legal right to ban exports. Mr. Buckingham stated no. Commissioner McClendon stated there seems to be some confusion that that is what the county is trying to do, which is incorrect. She then asked Mr. Buckingham if there are instances and what they have recommended which ignored his legal advice. Mr. Buckingham stated yes, the commission continues to put policy in the text, which is bad form but does not cause problems. Going on to the proposed study, and so I'm going to go to specifically Commissioner Hunter's and Commissioner McClendon's statement. Commissioner Hunter stated he remains amazed that we imagine that the degradations we are being put upon our planet by far too many use of fossil fuels is still a witch hunt. We don't have to guess about this any longer. We don't have time to ponder whether it is true or not. We know it's true. We seem shocked to be asked to do something about it. Moving on to Commissioner McClendon, stated she would vote against the motion, which was to basically not cherry pick what happens out there, whether it's exports and what, with the Commerce Clause. Whether the commission adopts it or not, this is what was adopted by the council, and they will proceed with the study. We don't need to spend time on the issue. She agreed with Commissioner
30
Hunter
seconds, please.
regarding anyone finding legal ways to get around the Commerce Clause, but we have to go through the process to make it clear to everyone on both sides of the issue what the federal laws are that have to be dealt with. And Commissioner Honkoop stated a study is not a good way to spend our taxpayer money. And also that we're spending time putting forth proposals in this particular area that is zoned for industry, and yet we are going to be going against federal law in order to try to go against the Commerce Clause. I find that to be very concerning that you're going down this path again, and here we are dealing with the water issue, and now we're going to deal with industry, and I don't know where this county is going to be. Seriously, thank you.
Anyone else want to speak to us in open session? Yes, Ms. Brenner.
Are we going to still introduce it when we haven't finished it? No. It's not going to be,
It's pulled.
oh, it got pulled, yeah, okay.
It's a bad idea. I'll leave it there. I'm not going to walk all the way down to that. No, go ahead.
Come on, you guys, make up your minds.
Patrick wasn't going to say anything, but he's.
Of course he was. Patrick loves to come up and talk to us.
Patrick Allison, 4825 Alderson Road, A-L-E-S-S-E. It's a complicated name. I left a document in your box last week, and it consisted of
I brought it up.
a piece of property at Birch Bay that really should be purchased for public parking. Think of this as a park and walk. This part of Birch Bay does not really have public parking. And yet we still have people that come down there and will park and walk. Very often it's like in one of the business parking lots. It's okay if it's during the winter, if it's a C-shop parking lot, because we're not open. But this is what they do. And it's okay. A lot of them just live at Birch Bay up on the hill. They come down, bring their dog, the dog gets them to walk. That's healthy. The price on the property is asking something like $98,000. Yes, it's money. The parking lot does not have to function in the wintertime, spring, summer, and fall, and it's right by public restrooms. So I'm not going to leave signatures with you yet. I'm collecting these now.
Okay, Ms. Brenner, do you have a question?
No, I wanted to say something to Patrick before you leave the podium. I brought that up when we talked about the Birch Bay plan today.
Okay.
And I don't know, was it you, Mark, or who? Somebody from staff, from the administration, said that would, at the most, that would allow, or maybe it was it you, Mike? Okay, yeah, it's only gonna allow for, at the most, with all the stuff that had to be done, three parking spaces. And-
Three?
Yeah. And
Well, listen, part of me bringing this up to you is that you have an opportunity to do for something for Whatcom County, for everybody here. Because a lot of these are people who live in Whatcom County. Now, I attended a meeting of the Farmhouse Gang. Yes, I'm a member of a gang. The Farmhouse Gang in Mount Vernon on Friday. And it dealt with ferries, issues, not the pretty ferries, but the ferries that take people around. And they were saying at the meeting, there's no public entity that takes responsibility for parking. So I'm asking you to take responsibility for parking. That would work for parking in the time when Birch Bay really needs it. The price is right. Okay.
$100,000 for 3 parking places?
Listen, no, it's more than that. And I remember the time that this council sat down and spent money on parking for the ferry. Oh, yes, we do have ferries on Lummi Island. And I figured out that you were spending $40,000 for each parking spot. Yes, this needs to be done.
Okay, anyone else like to speak during the open session?
I'm still amazed though that Patrick comes to so many of our things.
This is ridiculousness to keep you up, but it's a perfect time to make a point. Followed the critical areas thing all the way back to the advisory committee. There's been thousands and thousands of dollars wasted on that program. The TAC, the critical areas advisory, all the work that the commission has done. And then when we came last time and that presentation by PDS to try to get the Lahar language back in. Government is meant for the safety and health or whatever it says. And I feel bad for the committees. I feel bad for PDS. I feel bad for the Planning Commission. I wasn't going to say anything tonight, but just the talking about spending money. I was here when there's so much that I want to say. I don't know how to. Today, when you were looking at the critical area stuff, it was so complicated. How could you make a decision? I've watched those things go through, and whether it's the advisory or the commission or you, finally it just gets passed on. I mean, it's like some of the things today, because it's so complicated, you just want to, how much can you take? I'm going around, it's too late. Government has gotten too complicated. And I said to you when the amendments came up, and the people from Cherry Point were here, this is liable to be our Brexit, our county. People can't absorb all these regulations, and I know it's your responsibility to protect the county as well. But I appreciate little pieces of you, each one of you, I think, understanding the feelings of the people.
30 seconds,
and
please.
the people, I think, appreciate that too. So thank you in the areas where you've been able to empathize. I'm sorry. Carol Perry, Whatcom County.
Good evening. Eddie Uri of Bellingham and Resources for Sustainable Communities. I know we're all wearing down at this hour, so I'll keep it brief. So happy to see that you're moving forward with reviewing the updates to the comprehensive plan regarding Cherry Point. was a little disappointed things didn't go further today. We didn't get more done, but I know you're so much else you're dealing with. And I really see no problem in us taking the time to really, craft the best possible language. We've already come this far. We've gone through this robust process with the county staff and advisors, working with the Planning Commission, and I only caught the end of this previous comment as I walked in, but contrary to what's being said here, all the policies that we have in the Planning Commission recommended draft have been thoroughly vetted and deemed to be perfectly legal and defensible and within your realm. And frankly, we might like to see them go further, but all the more, while we take our time with these comp plan policies, we know that the moratorium that you currently have in place is set to expire by the end of this month. And really, on behalf of my whole organization and all of our many supporters in the area, we really strongly urge you to go forward and extend the moratorium for at least an additional 6 months, and then further until until everything that's updated needs to be updated, not only comp plan, but I know that your SMP is also out of compliance and due for an update and needs to be consistent with the comp plan. And the reasons for this are, that there are companies that may apply for permits to the county, even though they know that these projects may not be permittable by the Washington state agencies or by the federal government, and they may move forward and apply to get vested rights for permits regardless. We've seen this with SSA Marine having this permit on the books for over 20 years, may not have a path to actually get that built, but they're going to keep holding that and asserting that vested right and preventing you from changing policies accordingly. We have this island gas connector pipeline that's being cited to run through Whatcom County from Canada across to Vancouver Island for export of liquefied natural gas, despite being clearly would not be permitted by the state at this time or by the feds in accordance with upholding of LEMI treaty rights. Yet they're continuing to tell investors and state publicly they intend to apply for permits, and they can't do that at the county while you have this moratorium in place. The trick is to just until this study is completed, and granted your legal advisors there are questions that don't seem to be answered.
30 seconds, please.
Until this is complete and we have all the information you need to know about what your best options are. It's for everyone's best interest not to allow permit applications to get on the books until we know exactly how we're going to handle them, and that you need to state your policies really clearly up front, make it clear that you intend to uphold laws, and encourage federal agencies to enforce laws if they're not willing to do so automatically. That's what we hope to see you do. And just to be clear, I heard something got pulled?
Time.
This ordinance, did this get pulled? So it's not being introduced tonight, so.
It's not being introduced,
And
because we're not done with it.
there's going to be additions made to it, amendments? I'm just curious then, is it, if it's going to be introduced at the next meeting, in your current moratorium might be, if I'm correct, would expire March 27th? Could that not create a gap?
I think that we're talking about two different Cherry Point ordinances. There is an ordinance on for introduction tonight that was added to the agenda. That's another interim.
Right.
And then
Okay,
there's
the water ordinance. Wait, which
The
ordinance?
comprehensive plan one is the one that's pulled, but the interim ordinance on the moratorium is the one that's introduced tonight.
Got it. Thank you for clarifying that.
Sure.
Okay, just a little confused for a second. Thank you.
It's late, it's okay.
It is. Anyone else like to speak during the open session? Seeing no one, we will close the open session and we will go into natural resources.
Mr. Chair, we had one item, a request to grant the Washington State Department of Fish and Wildlife an easement for a hatchery that they're operating at the south end of Lake Whatcom. And the easement is only extended to and cannot be transferred from Fish and Wildlife. The committee recommended approval, 3-0.
Okay, we have a motion before us. Is there any discussion? If not, would the clerk please call a roll?
Barry Buchanan,
Yes.
Todd Donovan,
Yes.
Ken Mann,
Yes.
Satpal Sidhu,
Yes.
Carl Weimer,
Yes.
Barbara Brenner,
Yes.
Red Brown.
Yes.
That passes 7-0. Next is we'll hear from Finance and Administrative Services.
Mr. Chair, the Whatcom County Finance and Administrative Services Committee met this morning, and we have one item on the agenda, a request approval for the county executive to enter into a contract between Whatcom County and Commodity Credit Corporation for a 50% cost share for full purchase of development rights easements through the Agricultural Conservation Easement Grant Program in the amount of $593,020. This received unanimous approval, and I so move.
Okay, we have that motion in front of us. Discussion? Seeing none, all those in favor say aye.
Aye.
Opposed? That passes 7-0.
Mr. Chair, there was other business from finance. Do you want it now or later?
That's later,
Okay.
not far from here, but, we had one item that was held in committee from Special Committee of the Whole. That was a resolution initiating proposed comprehensive plan and zoning amendments. That's held in committee. Council appointments to boards, commissions, and committees. We have an appointment to make for the Portage Bay Shellfish Protection District Advisory Committee, and the applicant is Michael Shepard.
I move approval.
Second.
We have a motion and a second. Discussion? Seeing none, all those in favor say aye.
Aye.
Opposed? That passes unanimously. Next is executive appointments to boards, commissions, and committees. Request confirmation of the county executive's appointment of Sonia Max to fill the district at-large position on the Parks and Recreation Commission.
I move approval of the confirmation.
Second.
We have a motion and a second. Discussion? Seeing none, all those in favor say aye.
Aye.
Opposed? Passes unanimously. The second item under executive appointments is request confirmation of the county executive's appointment of Christy Roberts and Matthew McDermott to the Whatcom County Agricultural Advisory Committee.
I'll move approval by acclamation.
Second.
We have a motion and a second. Discussion? Seeing none, all those in favor say aye.
Aye.
Opposed? Passes unanimously. We have, out of the 9 items we have for introduction, item number 1 has been pulled. So items 2 through 9 are, I would entertain a
Well,
motion to
9
introduce.
is the new one.
This isn't a substitute version.
Yeah. We had only 1 through 8, but that's the new thing.
Okay, so your green ordinance, your green version is the number 2. Want a copy?
Not really.
Pass it that way then, too.
Oh.
Right? Don't be a...
Just had to give the stuff away this time of night, isn't it?
They're free.
Getting testy, what?
They're free.
They're free, they're free.
Okay, so items 1 through 9, and number 9 is the orange copy.
2 through 9, right, Mr. Chair?
Yeah, 2 through 9, that's what I meant to say. Anyway, I'd entertain a motion to introduce.
So moved.
So moved.
Second.
We have a motion and a second.
I got a question.
Sure.
Discussion. Can we vote on yours tonight?
Yeah, we are.
Okay, because he's putting it, you just said the orange one for introduction,
That's this one.
but isn't that yours?
No, that's different one. That's, will be in the other business,
What color was yours?
red.
It's pink.
Pink.
Pink,
Yeah, we'll be
okay,
dealing
pink.
with that in a moment.
Oh, okay, never mind. So,
Okay, so we have a motion and a second. Items 2 through 9, all those in favor say aye.
Aye.
Opposed? Passes unanimously. Now we'll go to committee reports from their other business. So anything more from natural resources?
Yeah, we had a presentation about the draft plan for the Birch Bay Community Park, and we were just talking about parking in Birch Bay. There was plenty of parking, 120-something parking units for that, but
yeah.
long way to go. It's an exciting plan, so,
He doesn't believe, Patrick doesn't believe you.
well, we did talk about it. We got maps with parking spots on them, so.
120 something.
But that was, and then we discussed the aquatic invasive species fee change, which was introduced just now.
Okay, thank you. Finance, was there anything else?
Mr. Chair, yeah, one item that came up was, we passed a resolution for recommendation to the full council that the committee moved to request that the administration create a request for proposal for the designated ADO organisation contract, which is due for renewal later this year, given changes to the comprehensive plan regarding economic development. So, I think Mr. Schroeder's looking a little confused, or? No, no.
Did we make them?
That's how we always work.
Apparently you always look that way, okay.
Especially after tonight.
So anyway, so we recommend to the full council for a vote to ask the executive or Mr. Longman and the executive's office to work on it.
Okay, so you're making that motion?
Affirmative.
Do we have a second?
Second.
We have a motion and a second. Any discussion?
I just don't remember the motion in committee. I remember the discussion. Okay.
Well, that doesn't mean anything.
Okay,
Trust but verify.
exactly.
Mr. Donovan?
Yeah, do we need to have any time frame on this, or is that just something we'll
Well,
expect?
it needs to be done quickly because the current contract expires, I think, at the end of June, so.
Tyler's got it.
Yeah, Tyler.
Yeah, I was just going to provide a little bit of background. Council can pass the motion. I'll work with Mr. Longman in regards to moving forward with the ADO and receiving. My understanding is Commerce will send a letter in early April recognizing who Whatcom County's ADO is. My understanding is we've had the port for about the last 5 years, I think. Council has, in the last budget cycle, put some money together for a economic development summit. And there will be kind of an upcoming economic development investment board meeting, EDI board meeting, that I think some of these conversations might be fruitful. And I think the offer has been to Councilmember Brown and Mr. Councilmember Sadoo to join that meeting when it's scheduled. It's not scheduled yet. To offer and for the county to designate an ADO doesn't require to go through the RFP process, but I'm happy to look into it, work with Mr. Longman and work with yourself, Councilmember Brown, in regards to it. I just don't want to commit today that the administration will go through that process, but I'm more than happy to look into it, and I've already kind of done that today.
Well, I think, based on the council's wishes to revisit economic development, which we did in the comprehensive plan, I think that the intent here is that the RFP for the ADO, the work the ADO is doing is reflective of what the comprehensive plan.
And to add to that, that's the value of the conversation today, and I'm gonna work with Forrest in regards to that language that council's interested in, the comprehensive plan from economic development. Look at what the ADO requirements are through the commerce and understand how the port accomplishes those, see where those overlap, see where they don't, and see how maybe additional work could come out. But it will probably be in the larger discussion that council wants to have in regards to Economic Development Summit and the EDI formation, and we'll commit to working through that process, and we'll just kind of go from there, is the background I wanted to provide.
So, okay, so that's the motion at the moment, and then there's a second subsequent motion I wanted to make, so.
Okay, any further discussion? No. Seeing none, all in favor say aye.
Aye.
Opposed? That passes unanimously.
And then, Mr. Chair, this wasn't discussed, but afterwards I realised I think it needs to be put forward, is that there is whether it's the State Department of Commerce, they send a letter or they send a letter asking us to designate who the ADOs. And I'd like to make a motion that we request the executive to delay the signing of that letter until we have established who the ADO is after the awarding of the next contract.
Is there any ramifications to that?
Yeah.
It could be, designation of ADOs and contract requirements and some obligations or expectations that the Port of Bellingham might have. I don't know. In the past, every time we've designated the ADO, we've had that conversation with council, and I expected we would do that again through that.
Well, that's fine.
So I don't want to do it.
And if there's some problems that we're not aware of, I'd certainly be happy to.
Yeah.
But I wanted to just express that we don't want to get in the difficult situation of having the letter signed and then awarding the contract to someone else.
So before indication to Commerce about who the county designates, we will bring it back to council and have additional conversations.
Okay.
Want to keep your motion?
I just for the record, sure.
Do we have a second?
Second.
We have a motion and a second. Ms. Brenner?
Well, I don't think it's appropriate. It wasn't even in committee. And I think it's more appropriate to wait until Tyler comes back with the information. I'm not comfortable just doing it beforehand.
Respectfully,
I think you're agreeing with them.
Oh, I am?
What?
Well,
I think
then I'm
she's
really
agreeing with you.
confused.
I don't think so.
No, so I think you're objecting to my motion, aren't you? Or are you objecting to,
No, I'm not objecting to what he wants to do, but you made a motion.
I made a motion to just ask the executive to delay signing the letter until we've gone through the process.
Well, I don't think we need a motion because that's what we're already doing. Sorry, Tyler.
Is there a due date on the letter?
I don't actually.
No, it's fine.
Let him find out first.
It's- I
Yeah.
guess my question would be, do we have a situation where we might have a gap where we don't have a designated ADO? And can we just say we'll extend them, the port is it until somebody else comes along?
Well, maybe not. Maybe we'll extend them because they're good.
I don't
continues
personally have
Yeah.
an issue with that. But the problem that the reason we're doing this whole thing in the first place is partly because we've changed the intent of what we want to do through the comprehensive plan. And the other is, my understanding is that the last award, and I don't know if subsequent previous awards of the ADO contract had been done without any RFP. So, and I don't like awarding contracts like this without going through a more visible process. So, and I also, for the record, I want to be clear, that the port is certainly going to be invited to respond, and the port may well end up being the designated ADO at the end of it. But I think we just need to make sure that what the port is doing as an ADO is consistent with what we want as we decide on the comprehensive plan.
He's bringing it back.
And so Tyler Schroeder again, it may be that this year, the administration, the executive recommends to continue with the port for a year, so we can go through this conversation. I will commit to come back and have that conversation with
Yeah.
council before the,
Before-
provide some details.
I'll
of
drop
where
the
we're at.
second resolution.
You withdraw?
I'll withdraw. It's getting late.
Okay.
Okay, so anything else from finance?
Mr. Chair, there was nothing else from finance.
Okay, Ms. Brenner, anything from Public Works?
We had a wonderful presentation from the sheriff on the sheriff's department. And we also had a presentation on all the problems with the differences in the speed limits and weirdnesses on Marine Drive. And hopefully those are gonna get rectified and they're gonna bring something back to us.
Okay.
Done.
So we have another item of business. Mr. Sadoo has
Yes.
provided us with a resolution. It's in the, I don't have the red copy, I have a regular copy. But
Yeah,
it's red,
I
pink,
read
or
it.
whatever you want to call it. So, Mr. Sadoo, you want to introduce it?
Yes, I would like to introduce this resolution. Do you want me to read it all?
Sure.
Oh, sure. Okay.
It's short.
This is a resolution dated March 7, 2017, condemning the recent hate crimes in Washington and other states. Whereas on March 3, 2017, Deep Singh Rai, a Sikh, was shot outside his home in Kent in an incident being investigated as a hate crime. And whereas in Kansas City on February 22, 2017, Srinivas Kuchibatola was killed and Alok Madasani was injured in another suspected hate crime against United States citizen from India. And whereas the immigrant community is an important part of Whatcom County and the nation as a whole. And whereas crimes motivated by hate of any race, creed, or religion must be denounced in the strongest possible terms. And whereas the Whatcom County is strengthened by its diversity and acceptance of all people. Now therefore, be it resolved that Whatcom County Council condemns these attacks and all others motivated by hate. Be it further resolved that Whatcom County Council stands in support of the immigrant community. Approved as of this date.
Okay, and that's your motion.
That's my motion.
Second.
Okay, we have a motion and a second. Discussion?
Thanks for doing that, Sal.
Yeah, thanks for doing that. Seeing no discussion? Oh, sorry, Mr. Brown.
Sorry, the only thing I don't know if I would like to suggest adding one more thing to this, which is that whereas members of some religious groups in Whatcom County have felt under pressure not to practice their faith.
No, this is about the Sikhs and they're not.
No, I know,
To
but
Sikhs.
Yeah, but
This is immigrants in general.
Yeah, it's immigrants in general. I think that I did discuss it with Forrest also. We wanted to keep it more general because I don't think that it has been individual incidents, but not a pressure on a Sikh religion not to practice it. But okay, individual people get sometimes into this kind of hate arguments and things, but not as a community. I think we have enjoyed a lot of sport in the last 25 years I've been here as a community, and we just did a interfaith service or prayer at our temple, and 500 people showed up, and there was like standing room only place there. So that really showed, and that was in January, that really showed that how much community cares. And the other part is that I have been getting phone calls and Facebook messages last 2 or 3 days, and then I put out a press release, and now people have been asking me how can we come and support you. So they're all coming on Sunday, this coming Sunday, between 12 and 2 o'clock, to show their support. So I think that we feel very comfortable and welcomed in this society.
Mr. Brown?
And first of all, I thank you for doing this. I'm very supportive of it. I don't want in any way interfere with what you're trying to do. I'm just trying to, I'm just very, based on some conversations I've had with people in the community, it's obviously an unpleasant situation. And I'll just say one other comment. So I'm going to actually withdraw my resolution unless you want it.
That's fine.
So I'll withdraw it. And I'll just want to say one comment about diversity. I was at a meeting on Friday with Pierre. I was in part of a group at a presentation with Justin Trudeau, who spoke and gave a presentation to the group. And he made it very clear he sees diversity as a strength, cultural and economic strength of Canada.
Yeah. I listened to that too, yes.
So it's unfortunate we are having the situation that we're having now.
Yes.
Well, I especially like what you wrote because I feel the same way too. I mean, not only have the Sikhs been an incredible part of the community, but it's always, it's been about love and peace with the Sikh community. It's never been about anything else, which was why it was very startling what happened.
Yeah, thank you. Yeah.
Okay, so all those in favor of the motion, say aye. Aye. Opposed? That passes unanimously.
Can we vote for it again? Because I'll vote twice.
It's not always been that way.
So, any other items of business from other council members? Mr. Weimer?
Yeah, I had one I promised to mention to people. I can't remember when, I think it was about 10 years ago, the council passed a unanimous resolution in favor of the reintroduction of grizzly bears into the North Cascades. There's been some inquiry about whether the council, there's a comment period open right now for the North Cascades National Park is looking at that, and there was a request whether there's interest in the council sending another comment into that. I'm going to send a personal comment. If anybody wants to sign on to my letter, you're welcome to. I didn't prepare a letter this evening, so I don't have anything to ask, but I just was going to make people aware of that. So if you want to sign on, give me a
I'll
holler.
sign on, but I think I'm meeting with someone too.
Well, we'll make sure the letter meets everybody's approval.
Yeah.
I don't want to upset Bruce, so I'm not signing
Yeah,
off.
seriously.
Definitely not.
Okay. Mr. Mann, do you have anything?
I have a couple, normally I don't do council member updates. Is that where we are right now?
We're actually on other items of business.
I don't have items of business, no.
Anybody else? Then we'll go to council member updates. Mr. Weimer?
Nothing.
All right, council member update from me. Number one, I attended the Recreation Northwest Summit, which was put on here in Whatcom County by our local nonprofit Recreation Northwest, and it was very successful. Jack Lyles spoke and sort of gave the welcome address, and we had manufacturers and tourism groups and hospitality groups and all kind of people connected to the recreation economy and just learn about how important an economy it is in Whatcom County and all the things that are happening and can happen. I just wanted to acknowledge that the success of that summit and the great attendance that was there and the good things people are doing. The second thing is the Incarceration Prevention and Reduction Task Force had a really great presentation last week, and with council's permission, I'd like to invite a member of the city staff, their district court, just to come and talk to us and share with you the news about how they have been responding to the booking restrictions and some of the alternatives to incarceration, and that we have essentially mandated through this jail crisis. And it's actually quite encouraging that we can make really significant improvements in incarceration prevention and reduction and get better outcomes and save money at the same time. And so I'll be bringing that forward to one of our committees. I'm not sure which one, but Ms. Brenner indicates.
Aren't you?
I'm in your committee, yes.
Yeah, let's
All
do
right,
it.
all right, we'll do it in Public Works, and I'll talk with the city about getting that set up.
Mr. Brown? Nothing else from me? Nothing?
Nope.
Okay, we are adjourned.
Man, you got loud with that.